Okay. All right.
All right, Chris, you ready? Hi, good morning, councils, interested parties. We're back on the record in the matter of the state of Georgia versus Cleve Adams et al. In 22 SC 183-572. Let me go ahead and take roll. Let me find my... All right, Mr. Stillwell, Mr. Botts, and Mr. Shard, good morning, gentlemen. Good morning. All right, Mr. Williams, Mr. Steele, Mr. Adams, and Mr. Nard, good morning. Mr. Kendrick and Mr. Weinstein, good morning. Mr. Huey and Mr. Matthews, Jr. and Sr., good morning. All right, Mr. Nichols, Mr. Harvey, and Ms. Westmoreland, good morning. And Mr. Ryan and Ms. D. Williams, good morning. All right. Mr. Atkins and ladies, Ms. Hill, I should say Ms. Hilton and Ms. Love, and Mr. Smith and Mr. Brown. Did you all send Mr. Uhelski to the cheap seats? Is that what you did? Good morning, Mr. Uhelski. I'm going to still say good morning to you, all right, because I know you. All right. Jurors here, sir?
Yes, sir.
All right. Anything I need to take up? Is Mr. Stevens outside?
Your Honor,
Yes.
may I ask the court that we get the exhibits that were filed under seal on the state's motion for limitation of reporting?
Okay, let me address that to begin with. I was going to set it for a hearing because I have to notify the media, and I was going to set that for let's give him 10 minutes. Friday the 2nd at 3 o'clock.
Okay.
So before then, state you wish to be heard on the issue of those particular filings. I'm aware of it. I need to set it for a hearing. So, given that I'm going to set it for a hearing not next Friday, I should say. Yeah, it is next Friday. Yeah, we're almost out of January. I'm gonna set it for next Friday. That will give us at least 10 days. So.
We will address it after court. If there's anything that we need to address.
So you'll deal with Mr. Weinstein or at least figure out an accommodation for those records.
Yes.
Okay. So, but for the motion. Because Ms. Love and Ms. Hilton, you'll need to notify the media as well,
yes.
The representatives, so I can properly hear that. Yes. Or if you'll get with Mr. Kearns, just so we send out something as well. If you have representatives that, because I don't know if they're the same council that have been coming here before, but just to make sure that we have the current media. So maybe we need to talk with them offline and figure out who their lawyers are, so we can send them a notice. Okay?
Yes, sure.
All right. So those of you from the media, if you would do us a favor, sometime between now and the end of the day, if you would get me a point of contact for who your legal representative is, name, phone number, email, we'll go ahead and notify them for the hearing on the 2nd of February at 3 p.m. Okay. I did. All right. Go ahead and summon our jurors. Can we bring in Mr. Stevens, please? Okay. Mr. Stevens? Mr. Seiden, did you have a question for me? Won't hear today. I just need, if you just give me a card, that'd be fine. Okay?
We filed it as reappearance. In this case, I unfortunately don't have the card with me, but we'll also file a response.
Yeah, if you follow it, yeah, that'd be great. That'd be fabulous.
Would you state your name for the record? Absolutely. My name is Leslie Gaither. I'm from Kilpatrick Township.
Is it Gaither?
Correct.
Okay. All right. All right. Thank you, madam. Okay, some of our jurors, please, sir. Morning.
That microphone on today or pick up your voice better. Just I'm swinging around.
All right, ladies and gentlemen, please be seated.
President, come forward.
All right, thank you, Sergeant Ingram. All right, Mr. Stevens, and Ryan, you're still on the oath, okay? Good morning, ladies and gentlemen of the jury. Good morning. All right. Zay? We kill the, Thank you. You done? Oh, good. Okay. We need to default that one too.
I keep the camera.
All right, ladies and gentlemen of the jury, good morning. Good morning. All right, you sound pretty good. Okay, all right, well, ladies and gentlemen, we're going to continue with the examination of Mr. Stevens. So, without further delay, I believe that Mr. Steele refinished?
Not yet.
Okay, all right, well, come on up.
May I, Your Honor?
You may, sir.
Good morning, sir.
One.
Your Honor, with the court's permission, can Mr. Kokomo show Mr. Williams exhibit number 31, Your Honor?
He may. He's already been admitted.
Recognize his album covers and the songs on each album, mixtapes, etc.
To my best.
Okay. Can I show you something, Your Honor? I'm going to mark it as Mr. Williams number, I believe it's 36.
35 right now, Mr. Stewart.
I think it's marked already, Your Honor, 36, if I may, and I'll come back to 35.
We've already, 35's been admitted, so if it helps you with your numbering.
35 is admitted, right?
Yes,
Okay.
36 is, would be the next exhibit in order. I mean, I don't care which one, well, how you have it numbered, but I'm just, if you're just looking for sequencing, 36 would be your next.
Okay. We're going to use 36. Let me get that in a minute, so I'll redo the, we'll redo the numbering, but I will come back to that, okay? Your Honor, I'd like to move for the admission. I showed you, Mr. Stevens. If you need to see it again, just tell this honorable court. But do you remember me showing you and you recognizing what I marked previously as Mr. Williams number 15? That's what we broke last time we were here.
My deal right here?
No, not that's the different number.
Oh.
Your Honor, I'll be object to this being admitted.
That's the video, Your Honor. That's when we stopped last week.
You want to approach for a second, please? Mr. Stevens. Just a minute.
got to pull up and listen to this number. He's got to pull up. Yeah. He asked him to get it done.
Yes. All right, can we summon Mr. Stevens, please? Thank you.
May I approach, Your Honor?
You may, sir. Yes.
May I approach you, sir? Mr. Stevens, I'm showing you what's already been marked as Mr. Williams number 15. If you could take a look at that. You remember seeing
A video that's a portion of. That's a screenshot, I guess, of a video. Do you remember that last week or the week before?
You ain't show me no video. You ain't show me no video,
You
dude.
want to see a video?
No, I mean, I know, I see what it is.
Okay. And do you recognize what that is?
Yeah.
And have you seen the video of that before?
TikTok. No, I think I seen one.
Hold on, approach for a second. Counsels.
Show us the video before you can say, let us see what video.
Mr. Stevens, I'm going to show you a video. It's marked as Mr. Williams number 15, okay? Mr. Kokomo, can you show it to the state again? you, sir. Mr. Stevens, have you seen the video that's marked as Mr. Williams number 15 in the past?
Yes.
And does it accurately depict what you just was shown by Mr. Kokomo?
Yes.
Your Honor, I move for the admission of Mr. Williams number 15. Both 15 would be the still photograph of the screenshot, and 15A would be on the thumb drive of the video.
Any objection?
The state has no objection to its admission. We would just ask to be provided with a copy of it.
All right.
I think that was okay.
Okay, defendant Williams 15 and 15 alpha are admitted and may be published as you see fit.
Your Honor, thank you, Mr. Kokomo, if you don't mind. I believe there's volume. Did you?
Oh, it's good. Okay. Yeah. All right. Okay. And do you to get?
I still got to get in.
Okay, when you get in, if you could like cut and paste the link because I've been struggling with it all day.
I mean,
Can you play the video if you don't mind? Mr. Stevens, do you recognize the person who is going around the circle of Mr. Williams number 15A?
Yes.
And who is that person?
LeBron James.
And did you hear him say, or did you see him rather, do something with his hand that's similar to what is depicted in Mr. Williams 15?
Yes.
And what did he do with his hand?
Wiped it across the nose.
And is that similar to what's in the indictment, the allegation that Mr. Williams?
Objection, Your Honor.
I sustain that objection.
Is it identical?
Objection, Your
I
Honor.
sustain that objection.
Is the indictment show that I showed you last week, if you need to see it again, I'll show it to you, and the exhibits and evidence of Mr. Williams wiping his nose, was that an overt act in count one?
Yes.
Same thing that Mr. James
Objection,
did.
Your Honor.
I sustain the objection.
Did you hear what Mr. James said as he wiped his nose and he was going around?
Yes.
What did he tell the jurors what he said?
Slime.
And is that similar to what you have been speaking about, the word slime?
Yes.
Objection is to similar to what Mr.
I sustain the objection as to form. You can rephrase.
Have you been asked about by the prosecution, has the indictment charged the word slime?
Objection, Your Honor, as to compound, question.
I sustain the objection as to form. You can rephrase.
Have you been asked by the prosecution about the use of the word slime?
Yes.
Same word that LeBron James used.
Yes.
Is there something sinister to you with the use of the word slime?
No.
You already explained to the jurors that this comes from, according to you, your background, your observation comes from a song by Mr. Carter or Lil Wayne. Is that what you said last week?
Yeah.
Sir, could you speak up, please, or speak into the microphone?
Yes.
Okay. And the wiping of the nose, is that anything sinister that signifies some sort of gang on Cleveland Avenue?
No, we only did that for like when we was smoking weed, and that's to say your weed loud. We put our finger on our nose.
And do you know whether besides Mr. James, other actors do that? Have you seen other people do
Your Honor,
that?
I object as to the form of the question.
I sustain the question.
Have you seen other basketball players do that same movement?
Yes.
Have you seen professional football players do that?
Yes.
Have you seen coaches in football, college football do that?
I don't know about no coach.
Okay. Have you seen college players do that?
Mr. Stevens, please speak in the microphone. Pull yourself up as close as you can to the mic. speaking.
I wasn't even answering it.
Huh?
I wasn't answering the question yet.
I know, but
Oh, you talking about, all right.
we're having a hard time. That's much better. See, everybody can hear you.
I got you.
Okay, all right.
Have you seen college football players do that same motion?
I don't recall.
Okay. How about Major League Baseball players?
I don't recall.
Is that something unique, the wiping the nose, saying slime, to some gang member on Cleveland Avenue?
No.
Okay. Now, I'm going to ask to approach and show you Mr. Williams' exhibit number 30. May I approach, Your Honor?
Yeah, sir.
May I approach you, sir?
I'm showing you Mr. Williams, number 30. Take a look at that. Tell me if you recognize
The image and writing in Mr. Williams, number 30.
Yeah, I recognize it.
And where have you seen it before?
Yeah, I mean, I recognize it. I ain't said I seen it.
Okay, well, how do you recognize it?
The people in it.
Okay, and have you seen it previously on social media?
Yeah, it was promoting a single at the time.
Okay, and did you see that scene that was being promoted at a time before this trial, let's say?
I remember getting promoted.
Okay, and did you see that on social media, that what I've shown you? I know it has an image now, but have you seen that on social media? I know it's not on a phone or a computer.
Yeah, and World Star. It was on World Star.
You saw it?
Yes.
Okay.
World Star. World Star.
Yeah, and does it have any changes, omissions, deletions from what you remember previously seeing?
No.
Okay. And is it accurate in what it shows in Mr. Williams number 30?
Yes.
Your Honor, I move for the admission of Mr. Williams number 30.
Your Honor, state objection. I don't.
Can I see it, please? Thank you, sir. I'm sustaining the objection.
Okay. You were asked by the Honorable Ms. Love earlier on your direct examination to show the ladies and gentlemen jury a Bloods gang sign. Do you remember something like that, demonstrating that?
Yes.
Do you know what a Crip gang sign looks like?
Yeah.
And could you, if I asked you, show the ladies and gentlemen jury what that looks like? And you made a motion with your right hand, and what type of letter did you make?
I see.
All right. And do you know what a Crip walk is?
Yeah, I heard about it.
Okay. And would you recognize a Crip walk if you were shown it? Or if you saw it?
Yeah.
Okay. And tell ladies and gentlemen jury what a Crip walk is.
I think it's a dance.
Okay. And the Crips, do you know, can you tell ladies and gentlemen jury what generally a Crip is known for? What is it?
What a Crip known for?
Yeah, what is it?
Oh, colors?
Okay.
A blue color?
What color?
Blue.
Okay, blue. And what is a Crip? If somebody's a member of the Crips, what type of organization is it? Is it a gang?
I don't understand.
Okay. If somebody said that they're a member of the Crip Would you believe that to be a gang? If they're a crip?
They just say they're a member of a group.
And is that a gang? Would you refer to it as a gang? If not, that's fine.
Organization gang, I don't know.
I couldn't hear you.
Organization?
Okay. Did you ever see the Super Bowl halftime show from 2022 with Snoop Dogg?
Yeah.
And tell ladies and gentlemen, jury, what you remember Snoop Dogg doing, or colors he was wearing, if you remember.
Blue?
Okay. And tell the ladies and gentlemen, jury, whether you noticed that Snoop Dogg, well, who is Snoop Dogg? Tell the ladies and gentlemen, jury, if you know.
Entertainer.
Well-known?
Well-known entertainer.
Performed at the Super Bowl?
Yes.
Along with other people?
Yes.
During that performance, did Snoop Dogg, did you notice, display a hand gesture similar to yours, showing a C, or a crip, gang sign?
Phil Snoop Dogg, 9 times 10 he did.
Okay. I'd like to show you, with the Honorable Court's permission, Mr. Kokomo's permission, a video of that performance. Tell me if you recognize it, okay? Your Honor, is that okay?
Yes, sir.
And this will be marked as Mr. Williams' number 37, Your Honor. You have to show it to the state.
Have you seen it, State?
No.
Why don't you show it to the state before you show it to the witness? Excuse me.
I'm trying to look at TV and I'm moving back up to.
Right, because he wants you close up in here, because when you sit back here, he doesn't.
When I thought I was gonna move back, I thought they were gonna play something right here. No.
He gonna bring the mic.
And you'll need to tell the court and the jurors and everybody, if you're showing just portions, what number it is. Yeah. Okay, thanks. Thank you. Mr. Stevens, were you able to view what Mr. Kokomo showed you as Mr. Williams' number 37?
Yes.
And is that an accurate depiction of what you described earlier of seeing the Super Bowl with a performer named Snoop Dogg?
Yes.
And was he making the references or the observations that you described to the jurors about the walk and the using the hand?
Yes.
And are there any, to your knowledge, deletions or additions or modifications, meaning were there any changes made to that, or is that how you remember it?
Yes, now I remember.
Okay, Your Honor, I move for the admission of Mr. Williams, number 37.
Any objection to Defendant Williams 37, madam?
No objection as to the video being played without sound and at the timestamps that Mr. Kokomo said that they would be played for Mr. Smith.
I would like to play the sound and the entirety.
Have you seen the entirety of it? Would you?
We just
All right, why don't you just, how long is it? Just come on up here and let's play it. And screen it. This would have been nice for you to do before we got in here this morning, Mr. Steele. So please, in the future, don't do this to all of us, okay? Okay? Sir, I'm talking to you.
Yes, sir.
Okay. This is not professional. Ladies and gentlemen, would you like to take a 5-minute recess?
Yes.
Okay, all right, why don't we do that?
Yeah.
You just said sound though. He said you are working on the sound.
We're gonna play some music.
How long ago this? Well, it's my generation.
Why is that?
And then there was another.
And I wasn't surprised.
So I sent it. Party one, when they saw it, I didn't realize they were playing each other. I was like, come on. It was like, oh, 20 years. I mean, I was like, it was a, no, it was a, I was just like, you don't understand my his team was.
It's over here.
It's not people. I listen to it, you know. I can help them great to see that. Legal. I know.
Okay, our jury is still in their headquarters. Has the state had an opportunity to preview the video?
We have, and Your Honor, I've spoken with Mr. Steele and Mr. Adams, and I have been shown the portions of the video that they wish to illuminate for the jury, which is at 1 minute and 12 seconds, according to what I've been told, where the performer is throwing up the Crip C, and then 1 minute 58 seconds through 2 minutes and 4 seconds, where the performer is doing the Crip walk. So as to those portions of the video, the state does have no objection. We would object as to the relevance of the entirety of the video being shown. And while the jury is out, I would like to address, for the sake of efficiency and expediency, defense number 36, which they have presented to us, and intend to introduce through the witness, Trontavia Stevens. If I may, I'm going to pass it up to the court. The state objects in total to any efforts to try and introduce Mr. Steele's writings through the witness, Trontavia Stevens.
All right, let's deal with is the video defendant Williams 36 or 37, Mr. Steele?
37.
The video that you seek to admit.
37.
Okay, 37. Okay, all right. Okay, so Mr. Steele, why you've indicated that you wish to have the entirety of the video played. What would the purpose be in terms of an evidentiary basis, so I can rule upon that?
Move for the admission of the entirety of the exhibit, because it would show the time, the place of the performance, the fact that it's at the Super Bowl, and then I would focus on two portions that we've eliminated for the district attorney's office.
Okay. What's the specific objection do you have other than that, Ms. Love? I mean, is there anything else that's in it that would be objectionable?
No.
Okay. All right, then I'll admit defendant's 37 over the state's objection. All right, this one here, defendant's 36, appears to be a a 10-page document, and I assume that this is some of Mr. Williams' songs. Is that correct?
Correct.
Okay, and what's the basis for the introduction of this particular document through Mr. Stevens?
Mr. Stevens already stated that he would recognize, I have to show him the document, Mr. Williams' albums and releases and mixtapes and the songs thereon. That is what the document purports, or what it is. And then the original witness for the state, Detective Belknap, this honorable court qualified as an expert in gangs, and he mentioned that a person with YSL would be wearing red. He showed a bandana in the right side of Mr. Williams. He picked out a photograph over my objection, and the court allowed it to be played on State's Exhibit number 1 or shown to the jury. And he said that people in YSL would not use the letter C because it's a rival of the Crips, and that's to show the disgust, I guess that's my word for the letter C. And here you will see many songs with the letter C. So that is the purpose of number 36.
Your Honor, if I may respond, of course.
Yes, go ahead, madam.
One, Detective Belknap never said that people in YSL would never use the letter C. There are Crips in YSL, so I know he did not say that. But two, Your Honor, the objection that we have is to Mr. Steele's handwritten, typed document, his writings being admitted through this witness. If he wants to ask the witness to name the songs that he is aware that his defendant, Jeffery Williams, has put out, he can, but to have a typed document, typed by the attorney, admitted through the witness is improper. There's no foundation that can possibly be laid. The witness didn't even testify that he knows all of the songs. It's just an awful way to try and backdoor some albums Mr. Steele wishes that the jury has in front of him, a compilation of defendants' I guess he feels most favorable releases. Notably, there are some Slime Season that aren't even on there. But besides all that, this witness is not a proper witness to introduce Mr. Steele's writings.
Mr. Steele, I'd probably sustain the objection on the basis of foundation.
I'll try to lay a foundation with the witness. I'll show him the document if he can identify it. I asked him if he knows the songs and the albums, and that is an accurate description, and it's not my right.
Still think you're going to have an issue as to foundation. I mean, if you're attempting to get in this compendium, you may have, there may be other witnesses or other particularized folks you may have to kind of do that. But at this point, I haven't heard anything from Mr. Stevens, and I would agree with the state that it would be, at this point in time, not admissible. Not to say it won't, but at this time, I would not allow it. So I'll just, for the record, just say that I have, it's been identified. If you want to try and admit it through somebody else, that's fine. Anything else?
No.
Okay, all right. 37 is admitted, 36 is not as of yet. And can we call Mr. Stevens, please? Back. Sergeant, summon our jurors for me, please.
All right, ladies and gentlemen, please be seated.
All jurors present, counsel.
Thank you, Sergeant Ingram. Mr. Steele, you may continue.
Your Honor, I move for the admission of Mr. Williams, number 37, based upon the foundation laid.
All right, any further objection?
No, Your Honor.
All right, defendants Williams 37 is admitted and may be published as you see fit.
It's the one and only people that put you through. You know what happened with the D.R.E.?
Yeah. Y'all know what this is. So can y'all make some noise for our man Snoop Dogg? Come on,
Top dog, bottom all, yeah, I'm burning it up. DPGC, go ahead and turn it on up. BBT, LBC, yeah, we hooking back up. And when they lay this in the club, baby, you got to get up. Love homies, drug homies, yeah, they giving it up. Low life, yo life, boy, we giving it up. Taking chances while we dancing in the party for show. Still my girl, 44, and she grabbing the back, they'll be shaking, looking at me strange, but you know I don't care. Step up in this mother, just a swing in my hair. Trick, put on and grip walk if you down with the shit. Take a bullet with some, and take this up on the shit. Out of town, put it down for the father of rock. And if you happen to get cracked, shut your trap. Come back, get back, that's the part of success. If you believe in the ass, you'll be relieving your stress.
It's the one and only D.R.E.
Dr. Dre, no busters.
You know I'm riding with the D.O.G.
West Coast, make some noise! Put your hands in the air. Everybody put your hands in the air. Come on, everybody put your hands in the air. Put your hands way up in the air.
Now let me welcome everybody to the Wild Wild West. A state that's untouchable like Elliot Ness. The track is your eardrum like a slug to your chest. Like the best for your Jimmy in the city of sex. We in that sunshine state where the bomb ass can't be. A place where you never find a dance floor empty. And pimps me on a mission for them greens. Bring me money making machines serving beans. I've been in the game for 30 years making rap songs. Ever since when these was wearing Sassoon, now it's 22. They clock me, watch me, drive and shining, looking like I robbed Liberace. It's all good from the April to the May. Your city is the palm and your city get paid.
So fire,
put your
hands in the air.
Can't point y'all on my head.
Mr. Stevens, the gentleman in the blue outfit on the screen, do you recognize and tell the jurors who that person is, or performer known by?
Yes, Snoop Dogg.
And the gentleman in the black clothing, do you recognize and tell the ladies and gentlemen that performer's name?
Dr. Dre.
And is this at the National Football League Super Bowl 2022?
Yes.
I'd like to take you, if Mr. Kokomo doesn't mind, specifically to timestamp 1:12. And do you see and can you articulate to the jurors what the gentleman who you identified as Snoop Dogg in the blue is doing with his left hand at that?
Making a scene?
Okay. And is that similar to the C that you showed the ladies and gentlemen jury earlier?
Yes.
And then the outfit, the blue outfit, is that right in the center? That's the gentleman you're talking about?
Yes.
And then if you can go, Mr. Kokomo, to 158 to 204. Did you hear in the words that that performer say something about a crip walk? Did you hear that?
No, I wouldn't even hear this.
All right, at 1:58, if you could play that to 2:04. And that person in the blue outfit, do you recognize that dance?
Yes.
And tell the ladies and gentlemen, jury, what that dance signifies.
A crip walk.
All right.
Dance.
Okay, thank you. Thank you, Mr. Kokomo. Now, do you ever know about a song, or are you familiar with a song that Tupac, you know who the performer Tupac is by any chance?
Yes.
All right. And do you know a song that he was featured on called Player Young Thugs? Are you familiar with that song?
I may have heard.
Okay. Well, do you know, you already identified Jeffrey as a performer. What's his performer's name?
Young Thug.
And do you know, if you do know, what, if anything, Thug stands for?
Yes.
Tell the ladies and gentlemen, jury.
Truly humble on the God.
And is that something that was personal or is personal to Jeffrey?
Objection. Speculation.
I sustain the objection.
Do you know whether
At
that
this
is
time.
personal? Do you know whether that is personal to Jeffrey?
Objection. Again, he can't speak to his mindset.
I sustain the objection.
All right. Throughout the years that you've known Jeffrey, has he encouraged you to read?
Objection. Relevance. And objection. Let's be clear about this.
I sustain the objection.
I don't believe it. All right. Thank you, Mr. Stevens. Your Honor, I have no other questions at this time.
Okay. Mr. Sharp?
May it please court, Your Honor. Mr. Stevens, good morning.
Morning.
My name is Max. My name is Max Shard. I represent Shannon Stillwell. Okay?
Yes.
Do you know Shannon Stillwell?
Yes.
And you identified him in court 2 weeks ago, correct?
Yes.
Okay. Did you grow up together with Mr. Stillwell?
No.
Okay. You said that you were raised on Cleveland Avenue, correct?
Yes.
To your knowledge, was Shannon raised on Cleveland Avenue?
No.
If you know, do you know where Mr. Stillwell was raised? If you know.
I think Thomasville.
One more time?
I'm not sure. I think Thomasville though.
Thomasville?
Yeah.
And is that an area of Atlanta?
Yes.
Where is that? Is it off of Boulevard?
No.
By Grant Park?
It's like by Moreland Avenue.
Okay, Moreland Avenue?
Yeah.
Okay. But it's a separate neighborhood than Cleveland Avenue?
Yes.
Okay. To your knowledge, you spoke a couple weeks ago about people being members of Rock Crew. Did you ever know Shannon Stillwell to be a member of Rock Crew?
No.
Did you know him to be an associate of Rock Crew?
I already answered it.
An associate?
Yeah.
What is your answer? I'm sorry.
I answered that. She asked me, Miss Love asked me the same question.
Okay, and your answer was no? Is it?
I answered, I said, if that means going to a club together, yes.
Okay, so your answer is, you said that you were a member of Rock Crew.
Right.
And you've been to a club with Shannon before?
Right.
Okay. All right. Do you recall when you first got to know Shannon? What year?
Probably 14, 13.
Okay. Now, you testified last week that you were in jail at the end of 2014, correct?
Mm-hmm.
Was that, did you know Shannon prior to going to jail that time or after?
I knew him before prison. That's why it was so easy for me to know.
Okay. All right. Now, Mr. Stevens, you testified over the last few days that you've been on the stand that you have committed crimes before, correct?
Yes.
Okay. And your testimony isn't that you're innocent of everything that you've ever been accused of, is it?
Say that one more time.
Have you been guilty of some crimes in the past?
Yes.
Okay. I would like to ask you about a couple of those instances, okay?
Yeah.
All right. Now,
Your Honor, and if this is as to certifies that have been admitted or tendered or things that have already been admitted as evidence, I don't have any objection. But I'd like for Mr. Short to at least identify to the state anything that he intends to ask or
Can you
inquire.
all come on up for a second, please?
okay. Mr. Stevens, you ready?
No, we're good.
Oh, okay. All right, I'm sorry. Mr. Stevens, you were charged in this indictment we're here for today, correct?
Yes.
Okay. And once you were charged with the indictment, you were able to become familiar with the indictment, correct?
Yes.
Okay. And you were charged in count 1, which was the RICO, conspiracy to violate the RICO Act, correct?
Correct.
Okay. But also, as part of the indictment, it alleged several past crimes that you committed, correct?
Yes.
Okay. I want to talk to you about, first of all, Overt Act 1, which was Fulton County case 13 SC 116787. It happened on January 25th, 2013. By that date, do you know what I'm talking about? Okay, it involves you allegedly, and you pled to this, committing aggravated assault on a police officer.
Yeah.
Are you familiar now?
Yes.
Okay. That happened in the apartment, or the parking lot of an apartment complex at 2616 Old Hateville Road, correct?
Yeah.
Okay. And you were charged with aggravated assault and possession of firearm by a convicted felon, correct?
Yeah.
Okay. Now, we heard earlier a lady came in and testified about how.
Your Honor, I object as to rule of sequestration and testifying.
I was saying this before, I'm not sure if Mr. Sharp.
Okay. There was a stolen car in the apartment complex that day. Are you now aware of that?
No.
Did you know that on that day?
No.
Did you know anything about a stolen car?
No.
Did you take any part in robbing someone or carjacking someone in Noonan, Georgia?
No.
Okay. And you were never charged with that, correct?
No.
And you have never admitted any guilt in that?
No.
Correct. Okay. Now, let's go back to the apartment where that you now know that a stolen car was in that parking lot, correct?
Yeah.
And you know that because you ended up being charged in that case back in 2013, and your lawyers told you about that, correct?
Yes.
Okay. That apartment complex, were you living there?
No.
Who was living there?
Associate.
Okay. And at some point, did you notice people seated in a car in the parking lot of that apartment complex?
Yes.
Okay. How long were they there?
Long enough to wonder who they were.
And how far were they from your associate's front door?
Maybe to that door right there, the courtroom door.
To the back courtroom door?
Yeah.
Okay, for the purpose of the record, is it about 25 yards? Is that fair?
However much the door is.
Okay, fair enough. So you notice men, and how many men were there?
2.
Okay, and they were in a car in the apartment complex?
Yeah.
Parking lot?
Yeah.
Okay. Why did you take note of that car?
Because they was acting weird. They had on black hoodies. They was just being weird.
Were they wearing police uniforms?
No.
Okay. What were you concerned of?
My safety. My safety.
Okay, could you explain specifically why those men sitting in that car made you concerned for your safety?
I was selling drugs at the time, and I was trying to protect my money, me, and my drugs.
Okay. And I think I know where you're going with this, but could you spell it out? What were you concerned those men were doing or planning to do?
Anything that can harm me. I don't know.
Does that include robbery?
Yes.
Does that include armed robbery?
Yeah.
Okay. And I know you said they weren't wearing police uniforms. Did you know they were police at the time?
No.
Okay. So when you saw these men outside, sitting in the car outside of your associate's door, what did you do?
I asked them if they could roll down their window.
Okay. What were you initially in the apartment building, the unit?
I was in like the hallway of it.
Okay, and so did you walk out and approach the men?
Yeah, not all the way up to their car though, from a distance.
Okay. And were you armed?
Yes.
Okay, with a handgun?
Yes.
Okay. When you approached, how did that go?
I did like this to ask them, can they roll their window down?
Okay. And what happened?
They just were looking.
Okay, did they eventually roll the window down?
No.
Okay. What happened next?
I pulled out my gun and like placed it on my side of my leg.
Okay. And how far were you away from the car when you did this?
A distance.
Okay. And what happened next?
He reached over and grabbed his walkie-talkie, and then I knew he was the police.
He being who?
The person that was in the truck.
The driver or the passenger?
The driver.
Okay. And you said when he reached and grabbed the walkie-talkie, what did you realize then?
That he was the police.
How did you know it was police then?
Because he had a walkie-talkie and he put it towards his mouth.
Okay. And when you realized it was the police, well, let me ask you this. Before that happened, before you realized it was the police, did you ever point the gun at either of the men?
No, I never pointed the gun.
Did you ever flash any gang signs?
No.
Did you ever say anything gang related?
No.
You said you were concerned about being robbed, victim of an armed robbery by these unknown men, correct?
No, I had all type of concerns.
Did this have anything to do with a gang?
No.
Okay. And when you realized it was the police, what did you do?
I didn't stand my ground. I took off running.
You said you did not stand your ground?
No.
Okay. And where did you run?
To the nearby woods.
And what did you do with the gun?
I threw it.
Did you ever shoot the gun?
No.
Did you ever point the gun at anyone?
No.
Look at the men seated out here as defendants. Did this case have anything to do with any of these men seated out here?
No.
Were any of them present at the apartment complex with you?
No.
Did this case have anything to do with Rock Crew?
No.
Did it have anything to do with YSL?
No.
This happened in 2013, correct?
That what the date say?
And were you charged at that time?
Yes.
Okay. And in fact, you pled to aggravated assault and possession of a firearm by a convicted felon, correct?
I don't think I was a convicted felon at the time. I think that was my first time being arrested. As an adult, I don't know.
And that may be my fault, Mr. Stevens. And it is my fault. Your Honor, may I approach?
You may, sir.
I'm going to show you what's marked State's Exhibit 11A. Recognize that?
Yes.
Is that your plea form? Or the certified conviction from that case?
Yes.
And you were correct. You were convicted of aggravated assault and possession of a firearm during commission of a felony, correct?
Yes.
Okay. You accepted responsibility?
Yes.
You did your time for that case?
Yes.
Okay. Back in 2013, did the state ever charge you with gang charges regarding this incident?
No.
Did they ever charge you with RICO or conspiracy to violate RICO back in 2013?
No.
It wasn't until 2022 that the state made out those allegations that this was related to a gang, correct?
Yes.
Okay. All right, Mr. Stevens, you were candid with us a couple weeks ago talking about your past drug dealing, correct?
Yes.
You admitted to selling drugs, correct?
Yes.
And you also indicated that you knew other people that you associated with YSL that have sold drugs in the past, correct?
Yes.
Okay. I want to talk about your drug dealing first, okay?
Yes.
We talked about the circumstances of your upbringing in Cleveland Avenue, correct?
Yes.
In your estimation, you know, we...
Very quickly. Yes, Mr. Matthews, thank you.
You go ahead.
Sure, go ahead, sir.
Need Mr. Stevens. Mr. Stevens, I was about to ask you about Cleveland, especially around the time, I'd like to ask about the time when you were little. Were there a lot of drugs in that area as you were growing up?
Yes. Yes.
Were there a lot of drug dealers?
Yes.
Okay. And this amount of drugs in the area, that existed before Rock Crew, correct?
Yeah.
That existed before YSL, correct?
Yes.
Okay. What years approximately, or how many years would you say that you sold drugs?
I really can't give you no approximate because I was back and forth from jail.
Is it fair to say more than 1 year?
Yes.
Okay. And generally speaking, what kind of drugs did you sell?
Weed, pills.
Okay. And you ever hear the term weight or moving weight?
Yes.
Okay. And that's used to describe a large amount of drugs, correct?
Yes.
Okay. Would you describe when you were selling drugs? And you're not selling drugs anymore, correct?
Correct.
All right. When you were selling drugs, would you describe it as large amounts or more smaller hand-to-hand transactions?
Oh, mine?
Yes.
Man. Nickel and dime. You know, yeah.
Petty?
Yes.
Okay. Would you sell in all areas? Did you have a specific spot where you sold, or did it change from time to time?
Yeah, it changed.
Okay. I believe that you indicated on direct that you have sold before at a couple of the gas stations in Cleveland Avenue.
Excuse me.
Yes, excuse me.
It's okay. And are those the only places you've ever sold drugs?
No.
Okay. In your experience, is it common that drugs are sold at gas stations?
Yes.
Gas stations have a lot of foot traffic, correct?
Yes.
People tend to congregate in the Cleveland Avenue area. Do they tend to congregate at gas stations?
Yes.
Okay. And if the police show up, you can flee from a gas station, correct?
Yes.
It's not like a house where you're linked to that one location, correct?
All right.
Are those all things that make it advantageous to sell at a gas station?
Yes.
Okay. I'm going to, Your Honor, may I approach? I'm going to show you what's already been marked and admitted as States 16U.
That's what I said, thank you. Thank you.
Mr. Stevens, do you recognize that document?
Yes.
And what is that document?
My plea?
Is that your plea agreement?
Yes.
Okay, and that contains factual acknowledgments that you initialed as part of your plea, correct?
Yes.
Okay. If I may approach one more time.
Okay.
I'm also going to show you what's been marked 157N and 82J. Do you recognize what those two pictures are of?
Yes.
Okay, and what is 82J a picture of?
Gas station.
Is that the gas station at 151 Cleveland Avenue?
Yes.
That's a Exxon?
Yes.
Okay. And that Exxon, is that a place where people in Cleveland Avenue would congregate to sell drugs?
And do other stuff too, yeah, just chill. Yeah.
Okay. And other stuff. Is there foot traffic at that location?
Yes.
Was that location close to your house?
Yes. You can walk to my house from there, yeah.
Okay. How about 157N? Is that a picture of 221 Cleveland Avenue?
Yeah.
And that's the blue chevron, correct?
Yes.
Okay. And again, is that a location where many people would sell drugs?
And hang out too, yeah.
And hang out. And is it fair to say that there's lots of foot traffic in that gas station?
Yes.
And that is close to your house, correct?
I can walk to it.
Okay. In the years that you lived at Cleveland Avenue, is it fair to say that there were hundreds of drug dealers that had sold at each of those locations throughout the years?
Yeah, you can say how many, yeah. I mean, yes. How many?
At the times that you personally sold drugs at these locations, is it a situation where you're the only one selling drugs at that gas station at that time, or are there other people also selling?
Yes.
Yes, what?
Yeah, other people.
Other people. And are we talking about other people that are working with you, or other people that are doing their own hustle at the same time as you?
Yeah, other people that are doing their own thing.
So you don't have, if I understand you correctly about these gas stations, you don't have exclusive rights to these gas stations?
No, how? No.
Okay. So other people can come and sell drugs there as well, even if you're already there.
Yeah.
And you can come sell drugs there, even if someone else is already there.
Yes.
Do you know what? Well, let me ask you to look at 16U. That is your and just to help you out, Mr. Stevens, that's the plea agreement. Okay. Could you look at factual acknowledgement number 12?
Yeah.
Okay, and factual acknowledgement number 12 says, the gas station at 151 Cleveland Avenue is a location where YSL associates sell drugs. Correct?
Yes.
Okay, and you've already acknowledged that you sold drugs there, correct?
Yes.
And I think that you indicated that another gentleman who's now deceased named Darius Ford sold drugs there as well.
Yes.
In the past.
Yes.
And you, in your estimation, he was associated with YSL.
Yes.
Okay. Now, so number 12, from what you're telling us, is true. That the gas station at 151 Cleveland Avenue is a location where YSL associates sell drugs, correct?
Yes.
Okay. Does this statement number 12, does it say only YSL associates are allowed to sell drugs at 151 Cleveland Avenue?
No.
Okay. If it said only YSL associates are allowed to sell drugs at 151 Cleveland Avenue, would that be true?
Objection, Your Honor, as to vagueness.
I understand the question.
If the acknowledgement stated that only YSL associates could sell drugs at that location, would that be true?
Objection as to vagueness.
It's speculation starts with
Well, do people in your life on Cleveland Avenue, and your familiarity with 151 Cleveland Avenue, did you know people who have nothing to do with YSL that have sold drugs at 151 Cleveland Avenue?
Yes.
Several people?
Yes.
Multiple people?
Yes.
Does harm come of them when they sell drugs at 151 Cleveland Avenue?
No.
Okay. Okay, let's talk about factual acknowledgement 13. Gas station at 221 Cleveland Avenue is a location where YSL associates sell drugs. Now, you've already told us about you and Big, so that is true, correct?
Yes.
Okay. Is that, I'm going to ask the same thing, is that location, from your experience growing up in the area and selling drugs in the area, is that a location where only YSL members are allowed to sell drugs?
No.
if someone who is not at all associated with YSL or Rock Crew or anything else sells drugs there, does harm befall them?
No.
Okay. Why did you sell drugs?
I was too lazy to get a job.
Does it go back to what Mr. Steele, Attorney Steele, was asking you a couple weeks ago about wanting fast money as opposed to taking your time and trying to earn the money? Okay. Do you view selling drugs as wrong?
Yes.
Okay. Did selling drugs give you money to provide for yourself at certain times?
Yes.
And what about your family?
Well, no life-changing money, but yeah.
Is it fair to say it was a way to get by?
I didn't even reach that point to get by yet, but it was.
Now, in a typical, well, the money that you receive from selling drugs, you testified approximately 2 weeks ago that you never gave Jeffery Williams any money. Is that true?
Yes.
Okay. And that includes any of the proceeds you got from selling drugs, correct?
Yes.
You never gave any of that to Jeffrey?
No.
Okay. Did you have any agreement with any of these gentlemen in the courtroom to split money or share proceeds from selling your drugs?
No.
Who got the money from you selling your drugs?
Me.
Was it your own individual decision?
Yes.
Did anyone put you up to it?
No.
Did anyone tell you to stand at 151 Cleveland Avenue?
No.
What about 221 Cleveland Avenue?
No.
Did you sell drugs to increase the notoriety of YSL?
Yes, I did.
To increase the notoriety of YSL? That was your purpose?
Yeah.
Okay, how does that increase the notoriety of YSL?
I already answered your question.
Do you know what I mean by notoriety?
I said, it made me look good and it made it look like I was getting money. I said I was though.
Okay, so you sold drugs to increase the notoriety of you. Okay, now I'm going to ask you, did you sell it to increase the notoriety of anyone else?
What? I said I did those things without permission, without anybody saying it, but that was why I was doing it though.
To do what?
Increase the notoriety.
Of who?
Of YSL. But didn't nobody tell me to do it though.
Okay. What about, okay. How about other people? Why would they be selling drugs?
Objection, speculation.
If you know, has anyone told you?
Any objection?
Okay.
Raised.
Has anyone told you? Has anyone told you their reasons for selling drugs?
Objection, that would be hearsay.
I didn't ask what they said. I asked if anyone told them.
Any objection?
Okay. Let's talk about firearms. Selling drugs, would you consider that a dangerous profession?
Yes.
Okay. Why is it a dangerous profession?
Selling drugs?
Yes.
Because it's illegal.
Okay. Any other reasons?
It's a lot of reasons, huh?
Do you become a target for robberies?
It's a lot of reasons, yeah.
Is that one of the reasons?
Yeah, that's possible.
When you sell drugs, people tend to pay in cash, correct?
Yes.
And when you're selling the drugs, you can have the cash on you, correct?
Yes.
And you also have the drugs on you, correct?
Yes.
And that drugs are worth money. People want the drugs, correct?
Yes.
Okay. If you're robbed selling drugs, can you just go to the police? Do you typically do that?
No.
Okay. As a potential robbery victim, when you're selling drugs, did you tend to keep a firearm on you?
Yes.
Okay. And what is the purpose for you to keep a firearm on you when you were selling drugs?
To protect me, to protect my drugs, to protect my money.
Okay. So you weren't carrying a firearm for any other purposes than to protect you and your things, correct?
Yes.
Okay. So when you were in possession of a firearm when selling drugs, you weren't doing it for any of these gentlemen here, correct?
No.
It was for you.
Yes.
No one told you to do that, correct?
Correct.
Okay. And let me just go back to selling drugs at all at these gas stations. You said it made you, did it give you a sense of you're doing something? People could see that you're doing something?
Yes.
People could see that you were making money even if it was illegal money?
Yes.
Is that what you mean by notoriety? It was giving you notoriety as
That's
someone
exactly what I meant. But you knew I meant that though.
Okay, well, I'm just trying to make it clear. So it's giving you a personal sense of notoriety that you're out here making it happen.
Yeah.
Okay? Were you doing that for any of these gentlemen?
No.
Okay? Were you doing that to increase any of their reputations?
No.
It was personal for you, correct?
Yes.
Okay. And when you were in possession of firearms in some of these cases, which you pled to, that was personal to you, correct?
Yes.
Your decision.
Yes.
Okay. All right. I want to just talk to you about a couple more specific cases. You're aware that in this indictment, you are accused of overt acts 48 through 50, which is Fulton County case 15 SC 135856 that happened on July 3rd of 2015. If I say the address, will you know what I'm talking about?
Yeah.
1813 Sylvan Road with Marquavius Gay in your car?
Yeah.
Do you know what case do you know what case I'm talking about?
Yes.
Okay. Now, that's a gentleman that was in your car when the police stopped your car and eventually found drugs, correct?
Yes.
Okay, and Marquavius Gay, is he out here today?
No.
Okay. And that case, specifically that case, are any of the people that are in your courtroom today, no one was with you that day?
No.
Okay. And, Your Honor, if I may approach.
You may, sir.
I'm going to show you Mr. Stevens. States Exhibit 189O and 59G. And specifically, Mr. Stevens, I'm going to ask you about 189O first. Is that the certified conviction from the July 3rd, 2015 case with Marquavius Gay?
Yes.
Okay. And you were charged with possession with intent, marijuana, possession oxycodone, possession of firearm during commission of a felony, possession of firearm by a convicted felon, DUI, and failure to maintain lane, correct?
Yes.
Okay. Do you remember why you were stopped that day?
Yes.
What was the reason that you were stopped?
Failure to maintain lane.
Okay. And when you were stopped, did the police approach your car?
Yes.
Did they end up searching the car?
Yes.
Okay. And were there narcotics found in the car?
Yes.
Okay. And what types of drugs were in the car?
Marijuana and pills.
Okay. And was there also a firearm?
Yes.
Okay. Mr. Stevens, do you have any gloves?
Yeah, behind you.
In this case, on July 3rd of 2015, with Mr. J in the car, was that your car?
No.
Whose car was it?
I think it was one of the guys I was with. I don't know. I don't remember.
And were you driving?
Yes.
Do you remember that marijuana that was found in the car? Do you remember where it was found?
Where?
Yes.
Yes.
It was under the passenger seat, correct?
Yes.
Okay. And do you remember how that marijuana was packaged?
Yeah.
Was it in a jar? Glass jar? Do you remember?
No, I think it was in like individual bags and then in a bigger bag.
Okay, that's what I wanted to get to. It was in a bigger bag. I want to talk to you about that bigger bag. Could you describe that bag? What material was that bag made of?
Cloth.
And do you remember what color that bag was?
Like tan.
Okay. Now, I'm going to show you what's been marked State 57G, which was taken off you 12 days later. Okay? A separate stop.
All right.
Do you recognize this bag?
That's the same bag. I mean, yeah, I'm saying, is that bag?
Well, this was taken, we're going to talk about this bag in a second, but what I'm asking you is on July 3rd, the drugs that were in that car, were they in a bag identical to this?
Yes.
Okay, and whose bag was this?
Mine.
And whose bag was the bag on July 3rd?
Mine.
You had two of the same bag, is that correct?
Yeah.
And these are Louis Vuitton cloth bags.
Yeah, it's for the shoe.
Tan color, correct?
Yeah.
So on July 3rd, 2015, you were pulled over and the 34 bags of marijuana individually wrapped inside a cloth bag that looked exactly like that was yours, correct?
Yes.
Okay. And can you just give the jurors an idea of what the street value of that marijuana you had in that bag was?
And they were like $10 for each one of them.
So maybe $340 total?
Maybe.
Okay. And you also had a small amount of cash on your person, correct? $130 about?
I guess so. You know what I say?
Okay, you don't recall?
That was 10 years ago, probably. Nah.
Understood.
However many years ago.
Okay. And the gun that was under the passenger, the gun was also under the passenger seat?
Yes.
Okay. And that was the gun you had because you were selling drugs, correct?
Yes.
Okay. You pled guilty to possessing that marijuana, correct?
Yes.
And 4 oxycodone pills as well?
Yes.
And you also pled guilty to that gun, correct?
Yes.
You took responsibility?
Yes.
Okay. That incident on July, that's overt act 48 through 50 in this indictment. Did that have anything to do with any of these gentlemen back here?
No.
Okay. Did that have anything to do with Rock Crew?
No.
Did that have anything to do with YSL?
No.
Back in 2015, when the state charged you for this crime, did they charge you with any gang crimes?
No.
Did they charge you with RICO conspiracy at that time?
No.
You pled guilty to the charges that you were charged with, correct?
Yes.
You took responsibility and did your time, correct?
Yes.
Okay. And it wasn't until 2022 that the state alleged that any of this was gang-related or part of some RICO, correct?
Objection as to when the state did what.
I stand objection.
All right. I'd also want to ask you about overt acts 52 to 55 in this indictment, and that's 15 SC 136875, and that happened on July 15th of 2015, which means 12 days later than that last case, correct?
Oh, yeah.
Okay, and you remember being arrested for drugs and then getting out and then being arrested within 2 weeks, correct?
I cannot forget it.
Okay, and that happened at 2915 Macon Avenue, correct?
Macon Drive.
Macon Drive, correct? And who lives on Macon Drive? Right by 2915.
Somebody.
And that's fair. One of your family members?
Somebody.
Okay. In that case, who was in the car with you?
A female and Shannon.
Okay. My client, Mr. Stillwell?
Yeah.
Okay. And that female, was that your girlfriend?
No, female.
Okay. Was she related, was she affiliated with you or Shannon?
Yeah, she was affiliated with me.
With you, okay. And in that case, you were charged with possession of marijuana with intent to distribute, possession of firearm with an altered ID, possession of firearm during commission of a felony, possession of firearm by a convicted felon, failure to obey stop sign, and failure to maintain lane, correct?
Yeah.
Okay, and is it fair to say that you were pulled over for failing to obey a stop sign?
Yes.
And failing to maintain lane? Okay.
Yes.
And you were driving?
Yes.
Okay, and where was Shannon in your car?
Back seat.
Okay. In that case, again, 12 days after the last case, drugs and a gun were also found, correct?
Yes.
Okay. And in that case, is this bag where the drugs were kept?
Yes.
And this bag was under the front passenger seat, correct?
Yeah.
Okay. So this bag was present in the car the day that Shannon was with you, correct?
Yeah.
But 12 days before, an identical bag had drugs in it and Shannon was not with you.
Yes.
In this case, the second case, the one with Shannon, do you remember how much marijuana and or pills were in the bag?
No.
Okay. To your recollection, was it weight or was it a petty amount?
Petty amount.
objection as to the vagueness of the word petty.
I'll sustain it.
Was it a matter of grams of marijuana?
Yes.
Okay. Were the drugs worth thousands and thousands of dollars?
No.
Less than that?
Yes.
Okay. And you pled to the drugs in this case?
Yes.
And you pled to the gun in that case, correct?
Yes.
Those drugs that were in that tan bag under the passenger seat on July 15th, 2015, those were your drugs?
Yes.
Did Shannon have any ownership of those drugs in any way?
No.
Did anyone else here own those drugs in any way?
No.
Did anyone have a claim to the proceeds of those drugs other than you?
No.
Okay, and same thing back in 2015 when you were charged with this case, you pled guilty and you served your time, correct?
Yes.
Okay, and back in 2015 the state never charged you with gang crimes in this case?
No.
They never charged you with a RICO conspiracy in this case?
No.
Okay, I'm going to ask you, Mr. Stevens, and we're almost done, okay? To look at 16U again. Okay, and that's the plea agreement that that you signed on December 29th of 2022, correct?
Excuse me, yes.
Excuse me.
Is that a yes?
Yes.
Okay, and you signed that plea agreement after being held at the Fulton County Jail, Rice Street, for 7 months, correct? About 7 months?
Thanks. Yeah.
And as part of this plea agreement, you were allowed to go home?
9 months. Yes.
Okay. Now, Mr. Stevens, do you have any legal training, you personally?
No.
No? Okay. The factual acknowledgments that you initialed, do you remember those?
Yeah, I remember.
Okay. Did you type them up?
No.
Do you know who typed them up?
That person, excuse me, no.
Okay. Could you go to page 1 at the top? Do you see a like a company logo at the top of that document?
Yeah.
Okay, and whose logo is at the top of that document?
District Attorney, Atlanta Judicial Circuit.
So that plea agreement has the insignia of the Fulton County District Attorneys on it?
Yes.
Okay, and who's the name on the left side of that document? The top left.
Excuse me.
Fannie T. Willis?
Bonnie Willis?
Yes.
Does it say her title on that document? Does it say District Attorney?
Yes.
Okay. Now, whomever prepared this document, when you received the document, was it your understanding that you could, was it your understanding that it was okay to refuse to initial
Hold on.
those acknowledgments?
My bad. What the first part was?
When you received those documents on December 29th, was it your understanding that you could just refuse to initial certain acknowledgments?
No.
You had to initial all the acknowledgments, correct?
Yes.
for the plea to go through?
Yes.
For you to go home?
Yes.
Okay. Could you look at factual acknowledgement 1 for me?
140?
1, number 1.
Yeah.
Factual acknowledgement 1 says, Young Slime Life, aka YSL, is an organization made up of 3 or more members or associates who share common identifiers that include but are not limited to colors, hand signals, and terminology, who have committed crimes intended to increase the notoriety, street credibility, and reputation of YSL. So, and you initialed that on December 29th of 2022, correct?
Yeah.
Okay. Let's just break that down a little bit. 3 or more members or associates. Did you, the number 3, was that a number that you came up with and told the state, make sure you put 3 in there because that means something to me?
No.
3 or more, that was it your words or whomever wrote the document?
Whoever wrote it?
Okay. What about, do you go around, in your everyday life and wherever in Atlanta you are, whether it's Buckhead, Cleveland Avenue, Moreland Avenue, do you use the word common identifiers a lot?
No.
Are those even terms you use, common identifiers?
No.
Okay. In defendant's factual acknowledgments 1, which you initialed, it uses the term associates who share common identifiers. Were those your words?
No.
Okay, what about, in going back to acknowledgement 1, but are not limited to colors, hand signs, and terminology. Are those your words?
No.
Mr. Sharp, before you pose another question, it's about the lunchtime hour, and I know I've been asked to take a comfort break, so this might be the time to accomplish both goals. Okay? All right, Mr. Stevens, come back at 1:45, please, sir. All right, thank you. All right, ladies and gentlemen, we're going to take a comfort break / lunch. Please be prepared to come back to your headquarters for 1:45. And remember my admonitions that I've given you. And with that, we'll see you back in an hour, okay? All right, all rise. Right on time. All right, ladies and gentlemen, please be seated. Our jury has left us. We'll see each other in an hour, okay? So 12:45, I should say 1:45, we'll see each other, right? All right, we're in recess.
Hey there, I'm Jesse Weber, and thanks for watching the Young Thug trial here at Law&Crime, where we bring you live coverage of high-profile trials and individuals accused of committing some pretty terrible crimes. I'll tell you one thing, it's a stark reminder that the world isn't always the safest place. Well, that is why I want to shine a light on this week's trial coverage sponsor, Morgan & Morgan. When you're injured, figuring out what to do next can be pretty overwhelming. That's where Morgan & Morgan, America's largest injury law firm, comes in. A whopping 3 million people turn to them every year. And their process is a game changer. Picture this. You submit your claim, you sign contracts, you upload documents, you communicate with your whole legal team, all from your phone. It's that simple. And what's even more impressive, an attorney reviews your case in just 8 clicks. That speed is remarkable. You submit a claim, they start fighting for you. And if you're concerned about costs, well, you only pay them if you win. There's no upfront fee. So if you're ever injured in an accident or at work, you can check out Morgan & Morgan. You can submit a claim in 8 clicks or less by visiting forthepeople.com/youngthug.
All right, Sergeant Ingram, everybody here?
Yes, sir. Everybody's present.
All right, thank you, Deputy Ham. All right, can we go ahead and recall Mr. Stevens, please?
Okay, we're good.
All right, go ahead and summon our jurors for us, please, Sergeant Ingram. All right, ladies and gentlemen, please be seated.
Everyone's present, gentlemen.
All right, thank you, Sergeant Ingram.
Thank you.
All right, Mr. Sharp, come on back, sir.
Your Honor, Mr. Stevens, just a couple more questions, okay? We were talking about, I believe it's 16U, your plea agreement, right?
Yes.
And on that plea agreement also talks about increased notoriety, street credibility, and reputation of YSL. Were those your words?
No.
Okay. Were those words of whoever wrote this document?
Yes.
Okay. Now, Mr. Stevens, since you've been released from jail, you're doing better, correct?
Yes.
You have a job?
I had one before this.
I understand. You were earning, you're out of the life of crime?
Yes.
Okay. When you were committing crimes, those were for your benefit, correct?
Objection, Your Honor, this is uncovered.
That's answered. I'll sustain the objection.
Okay. I have nothing further.
Thank you, sir. All right, Ms. D. Williams?
Good afternoon, Mr. Stevens. I'm Attorney Angela D. Williams. I represent Mr. Rodalius Ryan. Okay, so on January 4th, you say that you didn't know Rodalius Ryan, right? You gotta say it out loud. Did we repeat the question?
Yeah.
Okay, so on January 4th, you say that you didn't know Mr. Ryan, right?
So I ain't knowing that well.
Okay, so you never hung out with him in the neighborhood?
No.
You never called him?
No.
You never DM'd him?
No.
You don't know him personally?
No.
I have no further questions, thank you.
All righty. Mr. Harvey or Ms. Westmoreland? Okay, all right. Mr. Matthews?
Yes, Sean, thank you.
Mr. Stevens, good afternoon, sir.
Good afternoon.
You testified that you had a job before you actually turned yourself in back in May of 2022 on these charges, correct?
Yeah.
Okay. And you voluntarily surrendered yourself to the Fulton County Jail, correct?
Yes.
And when you were in that jail, you filed a motion for bond through your attorney, correct?
Yes.
But when you're in that jail, you didn't have a lot of choices in terms of how you could live your life when you were in that jail, in terms of what you ate, correct? What time to go to bed, correct?
Yes.
Using a cell phone, using a legal cell phone, correct?
Correct.
Taking a drive, correct?
You know where to drive.
Seeing your children. All of the things that in the free world we could do, correct?
Yes.
Right. Now, your lawyers filed a motion for bond on your behalf, right?
Yes.
And there's at least one or two motions for bond that was filed, right?
Yes.
And when your lawyers filed that motion for bond for you, they told the court that you had turned yourself in, correct?
Yeah.
They told the court that you had entered a plea back in 2015, correct?
Yeah.
And that you had done your time, right?
Yeah.
They told the court that you had lived.
I object to getting in with the lawyers.
What's the basis now? Okay, all right. I'll overrule it.
Thank you.
A little bit.
Mr. Stevens, do you remember the last question?
There you go again.
Okay. Your lawyers told the court that you were working, correct?
Yes.
They told the court that you had voluntarily submitted yourself to the jail.
Yes.
They told the court that you had children, right?
Yes.
They told the court that you had not been in any new charges or any new arrests since the 2015 when you took your plea, right?
Right.
That was all true, correct?
Yes.
You were living your life, correct?
Yes.
You were doing the things that were lawful and abiding in terms of the law, right?
Right.
And then you got indicted on these charges, right?
Yes.
And when your lawyer told the court all these great things about you to get you a bond, the district attorney's office, these people right here, they told the court that you were a flight risk, correct?
I'm going to object
Basis.
to relevance.
I sustain the objection.
Judge goes to interest.
I sustain the question.
Okay. Can I rephrase the question?
Yeah, you can.
Thank you. Mr. Stevens.
Hey, my bad. You asked me a question.
Well, I'm going to move
Not a
to.
question pending, sir, so he's gonna ask you another, one, right?
Oh, he had more further.
Okay.
I want to answer it. Right. Go ahead.
Okay. So, Mr. Stevens, when you were asking for that bond that we just got through talking about, the district attorney's office, they didn't want you to get a bond, correct?
Yes.
They wanted you to remain in jail, correct?
Yeah.
And their wishes were met. Your bond was denied, wasn't it?
Yes.
And you continued to sit in jail for that period of time, correct?
Yes.
You sat in the jail for many days after that, right?
Yes.
Many weeks after that, right?
Yes.
And some months, right?
Yes.
And during that period of time, you were scratching your head trying to figure out how it was that you couldn't get a bond, right?
Objection, Your Honor, to one relevant thing.
Yeah, I sustain the objection. It's a formal question.
Now, Mr. Stevens, you could not get out of jail, and then at some point, this 16U, this plea agreement came forth, right?
Yes.
And 16U that the jury's just heard me talk about, you initial those various paragraphs in each one of those pages, right?
Yeah.
And I want to take you directly to 16U to paragraph 14 in the factual acknowledgments. Can we go there?
Yes.
Now, in paragraph 14 of factual acknowledgments, it states that defendant cannot truthfully assert that anyone charged in this indictment is not guilty of the crimes as alleged in this indictment, and defendant, you're the defendant that's in this document, right?
Yeah.
That you, the defendant, Trontavia Stevens, will make no attempt at trial, prior to trial, or after trial, to exonerate or exculpate anyone charged in this indictment of the crimes alleged in this indictment, and that defendant, still being you, Trontavia Stevens, will not claim that anyone on this indictment is not guilty of the crimes as charged in this indictment. Those were not your words, correct?
Correct.
In your own mind, when you reflect on that paragraph 14, what does that paragraph 14 mean to you that is saying?
I can't say nobody guilty or not guilty.
That you can't come into this courtroom, and that you can't come into this courtroom and say to this jury that anyone in this courtroom, anyone that's sitting in this courtroom as a defendant, you cannot tell this jury, even if you knew that they were not guilty.
Mischaracterization.
I sustain the objection.
You can't come into this courtroom, Mr. Stevens, and you are allowed, you're not allowed, you're prevented from saying that anyone who's charged is not guilty, correct?
Yeah.
And that paragraph says that you cannot truthfully say it, even if you wanted to say it, correct?
Yeah.
And you cannot claim that anyone is not guilty, correct?
Yeah.
You can't do it before this trial ever started, right?
Right.
You can't come in here now and say it, correct? And when you leave, even after this trial is over, you can't even come back later and say that anyone was not guilty who sits in this courtroom, correct?
Yes.
As defendants. And then you signed the plea agreement, right?
Right.
And when this same district attorney's office, when they said to you that you couldn't get out for a bond, this same district attorney's office came to you and told you that you could get out if you took a plea, correct?
Yeah.
And that was within the span of you being in custody for 7 months, right?
9, yeah.
9 months. Is it fair to say that they no longer thought that you didn't meet the conditions?
Objection, Your Honor.
Basis.
Speculation.
I sustain the objection.
Now, changing gears, Mr. Stevens, you testified earlier that, just 1 second, Your Honor.
Yes, sir.
Thank you so much, Your Honor. And Mr. Stevens, Mr. Huey, I think you testified that you knew him from playing basketball at the court. Is that right?
Yes.
Okay. That was pretty much it. Is that right?
Yeah.
Thank you so much. Thank you, Your Honor.
All right, thank you, sir. Mr. Weinstein?
Thank you, Your Honor.
All right.
Good afternoon, Mr. Stevens.
That's no.
My name is Doug Weinstein. I'm one of Diamante Kendrick's attorneys. I believe that you testified that you met Mr. Kendrick in elementary school. Is that correct?
Yeah.
And then after elementary school, you didn't see Mr. Kendrick again until around 2012. Is that right? I know you're not necessarily good with years.
Yeah. I think I seen him after I got out of prison.
And Mr. Kendrick was not a member of Rock Crew, correct?
No.
Mr. Kendrick wasn't raised on Cleveland.
No.
Your plea deal doesn't mention Mr. Kendrick's name at all, correct?
Yeah.
Okay. When you were selling drugs at 221 Cleveland, was Mr. Kendrick there selling drugs with you?
No.
And when you were selling drugs at 151 Cleveland, was Mr. Kendrick selling drugs?
No.
You testified about the Web, 2531 Browns Mill Road. Did you see Mr. Kendrick at the Web?
No.
Are you aware of Mr. Kendrick being at the Web?
I don't recall, no.
Okay, I have no further questions. Thank you, Your Honor.
All right, thank you, sir. Okay, anybody else? For cross? Okay, all right. Any redirect from the state?
Yes, Your Honor, thank you. Mr. Stevens, you were asked on cross-examination a number of questions about the color blue. Do you recall that?
Yes.
Are there Crips that are members of YSL?
Yeah.
Is Gunna a Crip?
Yeah.
Is Duke a Crip?
Yeah.
Is Duke YSL?
Yeah.
Is he a member of Young Slime Life, the gang?
Yeah.
And what about Gunna? Is he a member of Young Slime Life?
Yeah.
All right. Is Gunna's real name Sergio Kitchens?
Yes.
Is Duke's real name Martinez Arnold?
Yeah.
You talked about, with, I believe, Mr. Steele, the acronym THUG, meaning, according to Mr. Steele, truly humble under God. Do you remember that?
Yes.
Okay. Would you tell the jury, you were also asked by Mr. Steele about songs that the defendant Williams has written or rapped. Do you remember that?
Yes.
All right. How many of the defendant Williams songs talk about slime?
A number of them? A number of them?
Okay. How many talk about F-ins?
Who?
F-ins. Guns.
A lot of them. Man, some.
How many?
They talk about, yeah.
Okay. How many talk about carbines?
Who?
Carbines.
I don't even know what that is.
How many talk about drugs?
A lot of them.
How many?
They do.
Okay, did you say a lot of them? Is that what I heard you say?
Songs. Just songs that mention drugs.
And how many talk about perks?
It's songs that mention drugs.
Name one that talks about perks. Push and P?
I don't recall.
You don't recall?
I mean, you want me to replay the song in my head, or you gonna play it for me?
It was played for you.
I done been in here for weeks. Like, a lot of stuff ain't just coming back to me like fast as you want it to.
Okay, and you don't recall whether Pushing P talks about pushing person.
If you play the song, I can let you know if it's saying something about a perk.
Fair enough. Okay. Now, you said a lot of them talk about guns, and a lot of them talk about crime, and a lot of them talk about drugs. Did I get that right? How?
A stain is the form.
I'll rephrase. Did I hear you testify that a lot of them a lot of the songs talk about drugs, and a lot talk about guns, and a lot talk
I said a number of them.
Okay. How many talk about the defendant Williams being truly humble under God?
A number of them.
Which one?
You gotta
Name one.
You gotta pay attention.
Just name one.
You like giving me like rapidly time to think, but if you give me some time, I can think of one.
How much time do you need?
You gonna let me go replay some music?
I'm gonna let you just sit there and think. How much time?
I ain't gonna come cause you like doing it how you doing it.
Is the answer 0?
No.
That's a stain is the form.
Let me ask a better question. Can you think of a single song right here as you sit right now that talks about the defendant Williams being truly humble under God?
One. I'll rule the objection.
A number of songs on the last album, Pump. I ain't with the song name. Oh, Dropping Jewels. He talked about God a lot in that one.
Okay. Please tell the jury what part of that song talks about the defendant being truly humble under God.
So in the beginning, he said, show me why I'm living, why am I remaining here? I know he wasn't talking about nobody else but God.
Oh, wait, did he say the word God?
You right.
I didn't say anything. I asked a question.
I knew what he was referring to because can't nobody else show you why you living.
My question.
No.
What are you answering me?
Did he say God? But I knew that he was referring to God.
So, can you think of a single song where the defendant Williams raps that he is truly humble under God?
Not under these circumstances.
So you cannot right now?
No.
Okay. You were also asked on cross-examination quite a bit about this plea agreement that you signed back in 2022. Do you recall being asked those questions by Mr. Steele?
Yes.
Do you recall being asked questions about it by Mr. Sharp?
Yes.
And do you recall being asked questions about it from other lawyers as well, representing some of the defendants?
Yes.
Let me ask you this. How many times did Mr. Steele visit you at the jail while you were at Rice?
No.
None?
For the RICO indictment?
In 2022, while you were incarcerated for the charges on indictment 22 SC 183572, how many times did he visit you at the jail?
Are you saying for the 9 months that I was locked up for this RICO? How many times he visited me? None.
You know, how many times did Mr. Steele visit you in jail, period?
Once.
When was that?
I was arrested for parole violation.
And so when was that? What year?
I want to say 2022 or 21, one of them.
2021?
I don't recall the exact year. I don't
It's
recall.
okay, but it's been in the last 2 or 3 years, is that fair?
Yes.
All right. And did you have a job back then?
No.
So, when Mr. Steele visited you, was it at your request or did he come down on his own?
It wasn't, yeah. Yeah, it was at my request.
Okay. And so what did you reach out? Did you reach out and ask for a lawyer?
Yes,
And did you ask Mr. Steele to represent you?
yes,
And you did not have a job?
no.
How were you intending that Mr. Steele, who is now Jeffery Williams' lawyer, how did you intend that he be paid?
I knew that probation revocations didn't amount to no more than $1,000, and I knew I had family that would help me out to get a probation revocation lawyer.
Okay. You were also asked some questions about, and so it's your contention that it was just a small amount, so family would have been able to afford it?
Yeah.
Did Mr. Steele end up representing you?
No,
Okay. And that was in 21 or 22?
I don't recall the exact year.
Was it before or after you were held on charges that are in this indictment?
This happened after, the indictment happened after.
You were also asked about whether certain words on State's Exhibit 16 uniform were your words. Do you remember being asked about that?
Yes,
Now, is it a fair statement you did not write this document?
I ain't writing none.
Is it a fair statement that you would not have ever even endeavored to write it?
What's the basis, sir? I'm sorry.
Leading from.
I sustain the objection. It's the form. You can rephrase it.
Would you have ever even wanted to write this document?
No,
Cause of speculation.
I sustain the objection.
Did you even want to write this document? Okay. But were you given an opportunity by the state and your attorney, through your attorney, to change any part of this document that you found to be false?
not giving an opportunity. I keep telling you, once I seen this exact paper, it was time to sign it. Like, we got this.
I'll rephrase the question. You're right. I'm going to ask it.
One at a time. So, Mr. Sharp? I'm sorry?
Madam Sharp, record, I'm going to ask that District Attorney allow Mr. Stevens to finish his answer.
He's not being responsive, so I'm going to overrule your objection, sir. All right, go ahead. Go ahead, Ms. Love.
Do you remember when you testified on direct examination, and I asked you to say that you signed this document? Was that the first time that you saw, and we read out a number of factual acknowledgments? Do you remember that?
One more time.
Do you remember on direct examination, like you remembered on cross when you were saying, she asked me that already? Do you remember my asking you whether the day you signed this document was the first time you saw factual acknowledgement number one?
Yeah, I remember you asked me that.
Okay. Do you remember saying, no, it was not the first day that you had seen?
No, when I signed it, it wasn't the first day I seen it. I said I had a number of days to sign it.
Okay, thank you. So in that time that you had a number of days to sign
I
this
could have
document,
changed something.
were you aware then that you could have changed something?
Yes.
And did you speak with your attorney about your knowledge that you could have changed something?
No.
You didn't talk to her about knowing you could change something if you want to?
Come on, something that was already wrote on the paper, or you can finish me.
Okay. Did you tell the state or your attorney, no, something on there is wrong?
No.
One of those is inaccurate,
No.
but you knew you could if you wanted to. Is that fair?
I sustain the objection. Mr. Stevens, again, pull your chair close to the microphone so we can hear you. Please, sir.
But were you aware that you could if you wanted to?
Change. Yes. What?
Now, you were asked by Mr. Steele about being kicked off of a tour. Do you remember that?
Yes.
And you were asked whether that was the reason you weren't at Jeffery Williams' concert when he was in Holly Grove, Louisiana. Do you remember that?
Yes.
And is it your testimony today, not last week or week before, that that was the reason you weren't at his concert?
I ain't able to give man one of y'all the reasons.
Okay.
Well, I probably told you that, what I say, it didn't make sense to, you trying to ask me something about other week. I already answered this stuff, man. I answered it, I want to answer today.
Does the truth remain the truth from week to week?
Yeah.
A sin objection.
So, was being kicked off of a tour any reason why you didn't go to Holly Grove?
It could have been.
Was Dolly, the defendant Williams' sister, kicked off of a tour? That same tour that you talked about being kicked off of?
I don't know.
Was DK, Walter Murphy, kicked off that tour?
I know I went home.
Was Dora kicked off that tour? Dora Green.
I don't remember who all went home. I know I went home.
Do you remember whether any of the people who were with you at the compound that night were kicked off the tour?
I know I went home.
Now, Mr. Matthews just asked you about factual acknowledgement number 14. Defendant cannot truthfully assert that anyone charged in this indictment is not guilty of the crimes alleged in this indictment. Is that one of the factual acknowledgements you signed?
I got it.
Initial. I just want to make sure we're looking at the same thing.
Yes.
Okay. SB, the defendant that you call SB, Shannon Stillwell, was he 30 deep?
He hung in McCannville, but he from Thomasville. You gotta be from these places to be saying that.
Okay. What about Little Ruby? Was he 30 deep?
Yeah.
I didn't hear that. What about Little Ruby? Was he 30 deep?
Yes.
And did he have to leave 30 deep? Or was he able to be YSL and 30?
I don't know.
When you and the defendant Williams and DK or Walter Murphy, when you all formed Young's Limelight, what were the membership requirements?
None.
None? How did you all decide who would or could be a member of Young's Limelight?
Nobody never did.
And when you say that people are members versus associates, is it still the case that you recognize a difference? That there's a difference between a member of Young's Limelight versus an associate?
Yeah.
You talked on cross-examination about living at, an associate living at the apartment where you were arrested and were charged with aggravated assault when you flashed your gun at what you later learned was a law enforcement officer. Do you remember that?
Yes.
Was that your car that the law enforcement officer was looking at that was 25 yards away?
I've never seen anyone looking at a car.
Did your associate come inside? What apartment did your associate live at? What apartment number?
I don't know the apartment number.
Was your associate arrested?
No, I was the only person arrested.
Do you remember speaking with your associate about somebody looking at the car?
No.
Mr. Sharp asked you about Biggs selling drugs on Cleveland Avenue. Do you remember that?
Yes.
Is Biggs' name Darius Ford.
Yes.
And is he the young man whose life was taken along with Christian McMillan?
Yes.
When I asked you on direct about the web, I asked you the address. Is the address of the web 2539 Browns Mill Road?
Yes.
How often did you visit the web in 2021 and 2020?
Often.
Would you describe what was inside the web for the jury?
TVs, computers, speakers, sofas, beds.
Was the web an apartment, a house, a standalone building, or something else?
A house.
Did you live at the web?
I've spent the night there.
How often did you spend the night at the web?
I can't have company where I stay at, so whenever I had a friend or something, I go to the web.
And the where you stay testified earlier that it is with a family member.
Yes.
And is that the family member that you've been living with your entire life?
Yes.
Did you have to pay that family member to live there?
No, just clean up.
That's reasonable though, will you agree?
That's a payment.
All right. Who lived at the web?
The web ain't have nowhere to go.
Whose place? Who owned the web?
I don't know the owner.
Did you own the web?
No.
When you wanted to go to the web, how were you able to get inside? Was the door always unlocked?
No.
How did you get inside?
Knock on the door?
Was there someone always there?
Yes.
So generally, who remained at the web at all times?
There was a guy who used to always clean up the house, clean up the yards. He older, he a homeless guy.
So did you have to pay anyone to stay at the web when you did stay at the web?
We was going in on the rent.
Okay. And so who were you giving rent to?
Talking about like, who? The house person? I don't understand.
If you were going in on rent, who were you giving the rent to?
The lady who got the house for us.
What's her name?
And I don't know.
You just gave her your name?
Yeah.
In February of 2005, I'm sorry, 2021, February the 5th, 2021. Around that time, would you have occasionally stayed at the web?
2005?
No, 2021.
Oh, I'm sorry. I could have been there.
After defense has an opportunity to look at them, I'm going to show you what I have marked. And Your Honor, just for the record, I will call them out in turn as State's Exhibit 21 uniform, 22 uniform, 24 uniform, 25 uniform, 25 uniform, Bravo, 31 uniform, 32 uniform, 33 uniform, 34 uniform, 35 uniform, and those are all. Now ask our legal assistant for legal assistance. But I'm going to send those over and make sure that defense counsel has an opportunity to look at these before we take them up to Mr. Stevens. Mr. Smith, could you please just...
You all want to, somebody want to come take a look at them?
21, 22. Yep. Yeah. So here's 25. And 35. You're Your Honor, may I approach Mr. Kearns?
You may, ma'am.
Thank you. Thank you. And Your Honor, with the court's permission, I will resume my questions after counsel for the defendant has looked over the marked exhibits. They've been turned over as discovery, but they've been marked, so I just want to make sure that they know what we're showing.
All right. Once the defense has an opportunity to take a look, and just let me know, and then so you can pause for the time being, ma'am.
Yes, Your Honor. Thank you. And Your Honor, being that this has been served, but I understand wanting to show it to clients, could the court give a 5-minute standing break?
Ladies and gentlemen, we're just recessing in place, so if you just want to stand or stretch, that's okay. And that includes anybody else. Again, let me know when you're done, gentlemen and lady.
No, it's good.
Okay, ladies and gentlemen, we're going to take 5 minutes for a comfort break, so we'll be in recess for 5 minutes, all right? All rise. You can come back in 5 minutes. All right, ladies and gentlemen, we'll be in recess for 5 minutes.
Mr. Steele, you through Mr. Hart.
Hey there, I'm Jesse Weber, and thanks for watching the Young Thug trial here at Law&Crime, where we bring you live coverage of high-profile trials and individuals accused of committing some pretty terrible crimes. I'll tell you one thing, it's a stark reminder that the world isn't always the safest place. Well, that is why I want to shine a light on this week's trial coverage sponsor, Morgan & Morgan. When you're injured, figuring out what to do next can be pretty overwhelming. That's where Morgan & Morgan, America's largest injury law firm, comes in. A whopping 3 million people turn to them every year. And their process is a game changer. Picture this. You submit your claim, you sign contracts, you upload documents, you communicate with your whole legal team, all from your phone. It's that simple. And what's even more impressive, an attorney reviews your case in just 8 clicks. That speed is remarkable. You submit a claim, they start fighting for you. And if you're concerned about costs, well, you only pay them if you win. There's no upfront fee. So if you're ever injured in an accident or at work, you can check out Morgan & Morgan. You can submit a claim in 8 clicks or less by visiting forthepeople.com/youngthug.
Okay, so let me just, for purposes of record, and correct me if I'm wrong, this is states 21 uniform, 22 uniform, 24 uniform, 25 uniform, 25 uniform Bravo, 31 uniform, 32 uniform, 33 uniform, 34 uniform, and 35 uniform. Is that correct?
That is correct, Judge.
All right.
And on two separate and distinct bases.
This pertains to all of them?
Yes.
Okay, all right.
First.
Can I see them to begin with?
Yes,
all right.
And just to give some context, Judge, I'll also pull out the ones that defense counsel admitted that are part of that same thread.
Yes. This is good.
That's federal right. Yeah, but this is redirect. Right. And the redirect should be, you don't have unlimited redirect. That's what I'm saying. Yeah, that's I'm still across. But I didn't do any cross at all. I got you. So it shouldn't come against me anything. Glad you did that. Glad you did that because it throws me off from looking for the red.
Yeah. I really turned on anyway, so it's like.
Here are defendants 2, 3, 4, and 7. Defendant Williams 2, 3, 4, and 7.
All right. Okay, Mr. Harvey. Also, the state has also given me defendants 2, 3, 4, and 7. So, what is your argument as to our objection as to the state's exhibits?
With regard to all of the aforementioned exhibits, and I love to use the word aforementioned, all those exhibits, Mr. Nichols is not a participant in any of them, number one. Number two, the only theory upon which these can be admitted, Mr. Nichols not being a participant, is 801D2E. You, Your Honor, had a hearing on 801D2E, and the court ordered the state to provide the court and the defense with what they contended to be 801D2E co-conspirators statements, co-conspirators exception to the hearsay rule statements. They provided the court with a nominal list of what they contended to be 801D2E statements. None of these exhibits were contained within, nor did the court rule on whether these statements, these social media posts or contacts were within the scope of 801D2E. My client was not a participant in these, and therefore they are hearsay, just rank hearsay as to him, and I would object to them coming in and coming into evidence as anything but hearsay. Number two, with regard in particular, specifically to Mr. Nichols. Mr. Nichols did not cross-examine. There is nothing to redirect with regard to Mr. Nichols. So number A, it doesn't come in, period. B, it's a confrontation clause violation under both the United States Constitution, the Georgia Constitution, and it is a violation of the statutory components of 801D2E. Number two, Mr. Nichols, I believe, is the only defendant that did not exercise his right to cross, and therefore this is redirect. There was nothing with regard to Mr. Nichols to redirect, and therefore he is entitled to a Rule 105 instruction that if the court deems this admissible, then it's not admissible as to Mr. Nichols.
All right, sir. Okay, Ms. Lowe?
Your Honor, one, Defendant Williams opened the door as to the Instagram posts. Some of them are already a part of the indictment as alleged overt acts. There was no objection when the Instagram posts that were admitted as defendants 2, 3, I believe, and 7 were tendered and admitted. These are portions of those same records that those defendants exhibits 2, 3, and 7 were a part of. This is not 801D2E evidence that should preclude the state from introducing them. The information that we are showing is further intrinsic evidence that the defense has touched upon extensively in its cross-examination, that the state should therefore be allowed to examine the witness on during redirect. This does not in any way present a confrontation clause issue. I believe that we have litigated similar circumstances extensively before this honorable court. And so I would ask that the court, as it relates to Mr. Harvey's client, overrule the objection he has made and deny him the request for a Rule 105 instruction under the circumstances. These are conversations that have been taken part in by members of YSL. And again, these are matters that were brought up on cross-examination. And were they not brought up on cross-examination with this witness, we may be in a different place in terms of my wanting to introduce the exhibits now through this witness, but here we are.
Okay, it looks like under 801D2E, characterize this statement as a co-conspirator statement, a party seeking admission which proved 3 things by preponderance of the evidence. Conspiracy existed, conspiracy included the declarant and the defendant against whom the statement is offered, and 3, that the statement was made during the course and furtherance of the conspiracy. So tell me how the states made those other 3. I'm in concurrence with you, Ms. Love, that Statements under 801D2E are not testimony for purposes of analysis under Crawford versus Washington, and such are not barred from admission by the Confrontation Clause. So I'm okay with that, but over Mr. Harvey's objection, of course. But what about the first three predicates?
One, Your Honor, these are, as far as having shown a prima facie case of a conspiracy existing, the court has heard testimony regarding the web being a spot for YSL. They've heard testimony regarding the fact that Trontavia Stevens sold drugs to increase and enhance the notoriety of YSL. They heard that on cross and direct. One of the allegations that we make in the indictment is that drug sales are one of the crimes that YSL members commit. In particular, we have, as a part of Mr. Stevens' factual acknowledgement, that YSL associates and members sell drugs at particular places. During cross-examination, Mr. Steele asked Mr. Stevens about living with his grandmother, and there were many questions that went into how his drug sales, does anyone in here benefit from his drug sales? Does anyone in here get the proceeds from his drug sales? And the conversations that the court is looking at are conversations between Mr. Stevens, who's on the stand, Mr. Lee, whom Mr. Stevens has already identified as the person that he held the conversations that defense counsel brought up on cross-examination, that he held those conversations with during that thread. They are talking about paying dues. They are talking about paying rent. Mr. Steele asked Mr. Stevens, didn't he live with his grandmother all of his life? And in fact, what is happening is the web is a trap. It's a place where YSL members sell drugs. We have evidence that will come in to further prove that assertion on our part. But Mr. Steele has now opened the door regarding the Instagram conversations and records that we served on counsel for the defense prior to jury selection in this case. So the conspiracy that we are alleging, of course, is alleged in count one. The participants, Mr. Stevens will identify, he has already identified many of them during cross-examination. And the content that the court has before it makes it, from our estimation, rather evident that these members or associates of YSL are acting in concert and for the benefit of themselves and the group itself. They are talking about paying rent. As a matter of fact, Jeffery Williams, on one of the, if I may have the exhibits to speak with specificity, Your Honor.
Which ones? The ones that you gave me, that have already been admitted?
No, the ones that the state tendered.
The ones that have already been admitted or identified. Is that what's what?
Yes, Your Honor.
Okay, all right. You want the ones that have been identified. All right, okay. I'll return those to you.
So, in State's Exhibit 21 uniform, we have Mr. Stevens, who is the witness currently on the stand, on February the 5th of 2021. Which one of y'all trying to shoot? Y'all shot at my trap. Then later on, in State's Exhibit 22 uniform, and to make very clear, State's Exhibit 21 uniform is page 30588 of an Instagram business record. Page 22 uniform is page 1624 of that same Instagram business record. And in State's 22 uniform, There is a conversation which actually begins on previous pages, I believe 1622, where the witness on the stand now tells the group or participants in the chat, neither one of y'all is having any company until I get my Timbs. So he apparently, it's our contention, and we'll find out from him, that they are at a particular place. We believe it's the web because there are references to it later. But he is at a place where YSL members consider one of their spots, and he is running things in terms of telling them, you all can't take any more company, you all can't do anything until I get the Timbs that were delivered here to our spot. Stacy.
Would you let Ms. Love finish and then you can posture your question? All right. Just hold that, Mr. Steele.
State's Exhibit 24 uniform and 25 uniform and 25 uniform Bravo were parts of the exhibits that Mr. Steele tendered for Mr. Williams. State's Exhibit 31 uniform, the middle of the page, where the witness on the stand on February the 6th says, what part you ain't hearing? Why everybody ain't got something to say? What you mean? If I can't afford it, no, they can't. That's why when a nigga be dead serious, y'all niggas need to stay in your lane. It ain't no joke. Y'all ain't giving me nothing. Then we have Do It Phil saying, I'm fist to bring some when I pull up. And the witness on the stand saying, y'all know I paid last month's rent by myself. Here go, same thing right here. Slug, I know what you did. And then he says, ain't nobody said nothing. And then he says, Big, don't pull off, fist to jump in with you. That's Do It for Phil. And then Slime Life Shorty says, send your bash app for Cash App. And then the witness on the stand sends a Cash App, a screenshot of his phone. He goes on and says, I've been paid the rent. He's already testified, and again, this is also for impeachment purposes because he testified that he wasn't working, didn't have a job, stayed with his grandmother. But he talks about having paid the rent. We will have another witness who has already given a statement to law enforcement that the web is a place the defendant Williams rented for YSL. We will have law enforcement officers who will come in here and testify about what was found when they actually searched the web. It is a place that has gotten shot up. It has surveillance cameras on the inside, and it was there were money counters, drug paraphernalia, and drug sale items and evidence inside of the web. You have the owner of the Instagram account asking how many niggas be sleeping there. Give a number. And then you have 4K having it his way saying it's an easy 100 a piece. Easy. You see them working in concert with one another. You see them in this Instagram. You see them working for the benefit of the enterprise that is YSL. We have 4K Tay having it his way. I just want to work. I'll even pay more. And then the witness on the stand, ain't nobody working. Everybody got their own motion. Find your purpose to the gang. And then Slime Life Shorty says, please and now. And then Real1_FR says 6 niggas sleep here. 4K Tay having his way says, I don't get it then. That's 600 right there. 12 if y'all go 200. They continue, the gang shawty, you know how it be. And then they're saying, the same person is saying too easy. 4K Tay then says $40 a day, $1,200 a month. And then we go on further down the line. And we're talking about 4K Tay having his way saying, I washed this hoodie. And then he says, and it's Slime clothing line. Only reason I wanted a funky ass little nigga. And then 4K Tay having his way saying, won't wear shit of yours without washing it for $1,000.
And then later on,
Okay, do any of these statements have, or referenced Mr. Nichols?
Your Honor, two things. They, as the court alluded to, they are not made to law enforcement. So there's not a confrontation.
Like I said, I'm not interested in that, but do these statements reference Mr. Nichols at all, or is he part of them at all?
He well could be. It would be the witness on the stand who will have to say.
Well, could be is not, that's supposition and speculation.
Well,
I mean, because they would need to have something referencing or tying Mr. Nichols. That's a part of his objection, I'm sure.
Well, the part of.
Well, here's my thoughts, the court's thoughts. Before I do that, Mr. Steele, what was your comment that you'd like to make?
I just wanted to know, I don't have the exhibit, was 22U a single page or is it a multiple page? That's my whole question. This one was referencing, she said, pages before may show. I did not remember 22U multiple pages. I just want to clarify.
This particular exhibit of 22U has only one page, but I will amend it before I actually have it admitted through or tender it through this witness.
Okay. Mr. Harvey, anything else before I go ahead and give you my thoughts?
Depends on what your thoughts are.
I know.
Give me my thoughts. Give me your thoughts.
All right.
And Your Honor, I just reiterate that this is a conspiracy that we are alleging in count one. These statements, Your Honor, are proof of the conspiracy. They don't have to directly mention Mr. Nichols in any way. That is the case with many of the overt acts that we've alleged in this indictment, and I believe that the court has heard this objection in different fashions a number of times.
But still, I gotta consider it.
Let me reiterate. I said before this trial started, give us the 801D2E that you intend to introduce at the trial, or we will be objecting. We're going to take trial time, and the state provided specifics of 801D2E. Specifics, and we litigated each one of those. And I said beforehand that we're going to be sitting here doing this at 4 o'clock in the afternoon. And that's why I'm objecting. I think it's disingenuous now to say, oh, boy, we think this is 801D2E. It's part of the conspiracy. It's not part of the conspiracy. It's to Mr. Nichols, who was in jail at the time these things happened.
Your Honor, this is redirected.
Yeah, I think Mr. Steele opened the door as to this, Mr. Harvey. So that's kind of the issue at this point in time. I understand where you're coming from.
Not as to me.
Well, that's the problem with having one of the challenges of having multiple co-defendant cases is that one may inadvertently affect somebody else. And that's your right as an advocate to make sure your client's interests are protected. But having said all that, here's my thoughts. I think the statements are admissible under 801D2E, and also that there's not a Crawford issue at this point in time. Now, whether or not there's a limiting issue at this point in time, I may give that as a jury instruction, but I'm not inclined to give right now.
Well, we would ask for it now because the evidence is coming in now.
See, but I don't know in context what else is going to be given. So that's why, I think it'd be better as a jury instruction at this point in time, depending upon what is actually put up.
But it cannot be redirect on a defendant that didn't cross. It can't be.
Your Honor, I would also point out that there was no objection when this was in.
And there's no scope either, Mr. Harvey. Unlike federal court, you can examine a party on just about anything at any point in time.
Well, the problem is we're on redirect. We're not on cross, number one. Number two, if it comes in against me, I will object.
Yes, sir, I don't have any issue with that.
But you can't hold me responsible for not objecting when it's not coming in to evidence against Mr. Nichols.
I'm not holding you against that. I mean, that's your job. That's your job. But yeah.
You're admitting it without a cautionary instruction right now. I believe I'm entitled to a cautionary instruction.
No, because it's a conspiracy. Some of these statements are going to be against, maybe directly admissible against some parties and not others. And that's the challenge of being, and the issue of being allegedly joined as co-conspirators is that's the power of it. But you know, I understand where you come from, but it also depends upon what is actually comes out as to whether or not those statements are truly going to be against. You know, does they prove that they went against X or Y, or does the jury understand that, hey, statements, how broad or how powerful a conspiracy is, but that's for them to decide.
No, that's exactly why there is a Rule 105, Judge. And I believe that at the time the evidence comes in, if it doesn't come in against a certain defendant, that's the purpose of 105. We can argue all day long. I get it. That's my position.
I understand, sir.
All right.
Okay. All right. Yes, Mr. Short.
May I add a specific objection? Yeah, my part.
Okay. Mr. Stillwell, what is that? What's the specific objection?
Well, Your Honor,
in those text conversations that the state is seeking to admit, first of all, I would point out to the court that Mr. Stillwell is not a party to any of those conversations as well. So we're similarly situated as Mr. Nichols. But also, Your Honor, if we're admitting these as 801 D2E, Your Honor just read the 3 prerequisites. And I noticed the state, when they were saying who said what, they say, well, 4K Tay having his way said this, and there's several other people that they don't know, as far as I know, they don't know who the government name attached to these people are. So I don't know how we can possibly make a pretrial determination or a admissibility determination about the admissibility of 801 D2E statements stated by people saying, oh, they're part of a conspiracy, speaking in furtherance of the conspiracy, when we don't even know who those people are.
Your Honor, we have.
Let me finish, Ms. Love.
And so if you look at those texts, there's certainly, I concede that Mr. Stevens may have identified himself on it. I don't know that for a fact. I'm trying to recall. We've talked about Wooney Lee. But there are other people that, to my knowledge, are unidentified, and I'm assuming they're unidentified because the state is referring to them by their screen names, and the state has provided no evidence whatsoever that those people, those individuals who are talking who are declarants in those text messages, we've received no information or a proffer or any sort of evidence that those people are in fact co-conspirators or doing anything in furtherance of a conspiracy. So I don't know how their words would be admitted under 801 D2E.
Your Honor, I thank Mr. Sharp for that, and I'd like to actually make sure that I offer that up and make sure that it's part of our proffer. Darius Ford, Wooney Lee, Jeffery Williams, Trontavia Stevens, Antonio Sumlin, these are all participants in this thread. And these are all people who are, with the exception of Mr. Ford, who are indicted co-conspirators as alleged by the state in 22 SC 183572. So if I was not clear, I extend my apologies to counsel for the defendants in the court, but these are, in fact, YSL co-conspirators, and do it for Phil is Mr. Farley.
Well,
Your Honor.
And, Your Honor, I'm sorry, Mr. Sharp. And, Your Honor, the foundation has already begun being laid with Mr. Stevens' prior testimony and his testimony about who is what person, as the Instagram handles show. But the foundation will further be laid as he gives the testimony that I expect he will regarding who these people are in these various portions of the Instagram thread and conversations.
And Your Honor, I would say, first of all, I don't think we should make any assumptions about what Mr. Stevens is going to testify to. But secondly, again, the state just identified maybe 5, maybe 6 individuals that they believe their government names are for the people that are involved in these threads. But again, Your Honor, you have them in front of you. There's, to my recollection, more than 5 or 6 participants when you look at all the threads together. So I'm wondering how out-of-court statements made by people who are not even identified would come in a trial against any of these gentlemen. Thank you.
All right. You all give me 5 minutes, please.
Does Your Honor want the exhibits? You want the exhibits?
Yes.
Hey there, I'm Jesse Weber, and thanks for watching the Young Thug trial here at Law&Crime, where we bring you live coverage of high-profile trials and individuals accused of committing some pretty terrible crimes. I'll tell you one thing, it's a stark reminder that the world isn't always the safest place. Well, that is why I want to shine a light on this week's trial coverage sponsor, Morgan & Morgan. When you're injured, figuring out what to do next can be pretty overwhelming. That's where Morgan & Morgan, America's largest injury law firm, comes in. A whopping 3 million people turn to them every year. And their process is a game changer. Picture this. You submit your claim, you sign contracts, you upload documents, you communicate with your whole legal team, all from your phone. It's that simple. And what's even more impressive, an attorney reviews your case in just 8 clicks. That speed is remarkable. You submit a claim, they start fighting for you. And if you're concerned about costs, well, you only pay them if you win. There's no upfront fee. So if you're ever injured in an accident or at work, you can check out Morgan & Morgan. You can submit a claim in 8 clicks or less by visiting forthepeople.com/youngthug.
I'll give it just a second.
I just want to make sure I get a continuing objection.
Just give me a second.
Yeah, sure.
Here's something else right quick. As I was just going to say, you can sit down and write. I'll call it back.
Okay.
Okay, Mr. Harvey, you said you wanted a continuing objection.
I do want to continue. Judge, to the admission of those exhibits that you specified that are part of the record. Yeah, and, I understood that the questions that were asked originally were asked specifically with regard to Mr. Williams, and no one else really. So I understand what those.
Yeah, I'm going to rule. I don't think you probably want to wait until I rule, but I do understand what you're saying. Okay, here's where we are at this point in time. Characterize the statement as a co-conspirator statement. Party seeking admission must prove each of three things by a preponderance of the evidence. So the state would have bears the burden in this particular circumstance. One, that a conspiracy exists. 2, the conspiracy includes the declarant, person speaking, and the defendant or defendants against whom the statement is offered. And 3, the statement was made during the course and in furtherance of the conspiracy. And that is United States versus Flores, 572 F. 3rd, 1254. Also, co-conspirator statements may be admitted if the proponent shows by preponderance of the evidence the following the 3 elements I just mentioned. But it says also, where statements, however, admit participation in a crime, but do not evince an intent to further criminal activity, Rule 801 D2 does not authorize their introduction. And that is State versus Lane, which I think we argued before, and that's 308 Georgia 10. Statement that merely spills the beans, discloses a scheme, or informs the listener of the declarant's activities does not constitute a statement in furtherance of the conspiracy. The state has offered for my consideration as well, Crawford versus the state, and that is 294 Georgia 898, pinpoint 809. Such independent prima facie evidence of a conspiracy need not be adduced prior to the admission of the hearsay statement at trial, so long as sufficient evidence thereof is presented prior to close of evidence. And in order for a conspiracy to exist, there must be an agreement between 2 or more persons to commit a crime. Such agreement need not be expressed, nor does it require a meeting of the minds to the same degree necessary to form a contract. All that is required is tacit mutual understanding between persons to pursue a common criminal objective. The challenge that the court is facing at this point in time is that I don't believe I've heard enough as to determine whether or not there is sufficient evidence. And I know the state's telling me, y'all telling me that as long as you present it prior to close of evidence, I'd like to hear a little bit more in terms of context in regards to Mr. Harvey's objection specifically. So I haven't heard enough as yet that Mr. Nichols is truly involved in this, but once I do hear that, you can admit or represent the particular evidence, but for now I'm going to sustain Mr. Harvey's objection.
So, Your Honor, as it relates to, there were a couple of things that we'd like to say first. Thank you, Judge, for the, yes, thank you, first of all, for helping us to understand where the court is.
See, I need to know which statements you're offering. I mean, the challenge that Lane kind of just presents is that you just can't throw out all these statements. You've got, and also there needs to be something which is going to provide the court or some indicia that's going to tell us that you're going to present all of this by your closing chief. So I haven't heard anything about these particular statements yet. They weren't included as part of the pre-vetting process, but like I said.
So, Your Honor, part of what, as the court knows and the court is aware that we have to do is prove that we have an enterprise as part of count 1. And so part of what we are doing with these records as well is showing the existence of an enterprise, an association between persons that are participants in this thread who the state alleges are YSL associates.
Don't have any issue with that. What about specifically Mr. Stevens? I mean, Mr. Nichols?
So we've already heard Mr. Stevens, who is on the stand, testify that Quay and the other Quay, Marquavius Huey and Quamarvius Nichols, are members of the Young Slime Life criminal street gang. He testified to that week before last. So he has already been identified as a member of this gang. And in these Instagram messages, or in this Instagram conversation, you hear the witness on the stand now talking about the gang. He's talking about what the gang has to do. Everybody do their part so we don't have problems, gang. Can we all do that? And then you have Defendant Williams saying, this shit ain't about no money, twin. I pay for everything. And then Defendant Williams, it ain't about that. And then Trontavia Stevens, who claimed on cross with Mr. Steele that after Mr. Williams got a record deal, they went their separate ways. But you have Mr. Stevens, February the 7th, 2021. How long before the place got shot up? 3 months before one of their other traps got shot up, talking about somebody trying to shoot up his trap and responding to Mr. Williams, whom he said he went his separate ways from. Only thing I was saying is, I can't afford to take care of this family by choice. Not yet anyway. When the only thing I make is $400 off each one, I pay $1,500, that will hurt. And then you have them going on talking that's on page 1709 of this Instagram business record. And to be clear, the business record is from the document that we served to defendants, and it has a PDF number.
I don't think their issue is the foundation of the Instagram business record. My concern at this point in time is I hear everything you're saying is that some more foundation or nexus is going to have to be shown, at least from the court's perspective, to not run afoul of Davis.
Right, Davis.
I should say Lane, in order for me just to be able to hear something else about tying, since Mr. Harvey has specifically objected as to his client. So that's my concern. I think you've been able to show at least part of it in terms of gang activity, but it would be helpful if there's more nexus as these conversations as it relates to Mr. Nichols.
So, Your Honor, if the court permits, then may I suggest that I be allowed to ask questions before the court admits any of these to establish the nexus, the context, the foundation that the court seeks that we find as it relates to the state's exhibits that I've tendered, and that the court give a sort of limiting instruction stating that until such time as the court deems it proper, the jury shouldn't consider them against only Quamarvius Nichols. And then at a later time, when we've satisfied the court's concerns regarding Mr. Nichols, the court tells the jury, especially when the door was opened and the rule of completeness, we'd argue, should allow us to get into these documents, since Mr. Steele has already introduced his portions of them, that until such time as the court tells the jury that right now we're considering them against 5 of the 6 defendants.
I would think that should have been done prior to us doing anything in terms of presenting this in front of a jury. Listen, I know that your assertion in the courtroom is that Mr. Steele opened the door as to that. So, yeah, but it's going to have to be taken up at some point in time. So we may not be able to do it today, unfortunately, but I think you're going to probably end up having to do that in order for these records to be admissible, or at least the court to make a threshold determination as to them.
And Your Honor, I'd also point out that in a conspiracy, as Mr. Floyd, who's our person who helps with this every day, is every defendant is responsible for the acts of every other defendant. And in as much as, regardless of where Mr. Nichols was at the time that these statements are being made, we've at the very least shown made a prima facie showing that there is a conspiracy and that there is a gang, which the courts have deemed conspiratorial on its face.
I think you've got 1 and 3 already. A conspiracy existed and the statement was made during the course and furtherance of conspiracy. I just think that you have the issue that I'm kind of teetering on right now is the conspiracy included the declarant and the defendant. So the declarant, person speaking, and the defendant against whom the statement is being offered. Now, I know it's pretty broad in the conspiracy about what may be said about whom, and that's the powerful thing about a conspiracy, but still, that's where, Lane, kind of cautions me about that. So, that's why I'm saying that you may need to kind of just put on a little bit more, show how you've met the second prong, which is the conspiracy included the declarant and the defendant against whom the statement is being offered. And that's kind of what we were trying to do with the 801D3 issues, is to kind of parse out which ones or which statements are... You find something funny, Mr. Short?
No.
Okay, all right. Just want to make sure. All right. So that's kind of where we are.
So that I'm clear, the court is it the court's instruction that we need to show that that Mr. Nichols was a part of the conversation, or because as the court has reminded us many times, the defendants, as with each of the alleged overt acts in the indictment, they don't have to be a part of every overt act. And our contention is that these conversations are overt acts in furtherance of the conspiracy, which are admissible against every participant in the conspiracy. And inasmuch as Quamarvius Nichols is a part of this alleged conspiracy, these Instagram record conversations should be admissible, should be admitted against him, as well as each and every one of the other defendants seated before Your Honor today.
Just saying, that part of the conspiracy ain't proof. He ain't part of the conspiracy. There's no proof of the conspiracy, and he is not a participant in these phone conversations.
And Your Honor, just for the record also, you keep saying only Mr. Nichols. Mr. Stillwell is not a participant. Conversations either.
That's what.
I don't know why the state keeps saying 1 out of 6.
And Your Honor,
and neither is Mr. Kendrick.
So Your Honor, that's exactly the issue that they have been trying to sort of push all along. It's an effort to de-aggregate or to pull apart the conspiracy itself, count 1 itself. And in a circumstance such like this, in this type of case, that is why we have the laws that we have. They are quite liberal, they are quite broad, and they are meant to reach beyond the contention of defendants who want to assert, well, I didn't have anything to do with that act, so you can't hold that against me. I didn't have anything to do with that one, so you can't hold it against me. This is exactly the type of circumstance that the Georgia RICO laws were designed to encompass. And for that reason, we are asking that the court allow us, prior to the jury being sent home today, to get into these conversations by the witness on the stand, the defendant Williams, Wooney Lee, who is also on the indictment, Antonio Sumlin, who is also on the indictment, Miles Farley, who's also on the indictment, all of these members of YSL and associates of YSL. This is, if they were able to make the type of argument that they are attempting to persuade the court about now, then there would never be a place or an instance for this type of action to be brought, because that would be the argument that would allow them to escape being held responsible for acts of these natures.
Allow the state to eliminate their burden of proof beyond
pulled out. That's what the state is asking you to do. It's a matter of proof.
Not at all.
It ain't a matter of say so. You can say whatever you want, but the proof comes from the witness stand, and the proof comes from the admitted evidence.
And Your Honor, we would argue that this is admissible evidence, and it is what they are arguing goes to the weight, not its admissibility, and that they can cross or not cross or argue in closing that their client wasn't a part of the conversation, but that's their right and ability at every juncture with every piece of evidence. They have done it thus far. They have attempted to cross every witness. Was my client there? And this is exactly what can be done here, and this is exactly the exact type of evidence that the state has offered previously, the court has found admissible, and that our contention is that the court, in this instance as well, should find admissible against every defendant seated in here right now.
Yeah, except
without more, actually, because we have shown the
Hold on, I can't listen to people simultaneously. So
the same thing all day long.
Without more, because we have made the we've made the requisite showings.
Except for the fact that I didn't cross. I didn't make an opening argument, and I didn't cross this witness. So that is a distinguishing fact. Sorry, I get the floor now. I get the floor now.
Okay.
That's a distinguishing fact, and it's still a matter of proof. A say-so, an argument, doesn't meet the state's burden of proof. It's as simple as that.
Well, it wouldn't, Mr. Harvey, with all due respect, it wouldn't make a difference whether or not you crossed them or not. It's a conspiratorial statement. That's what they're offering it for. So whether or not, I understand what you're saying, but I don't think that will affect its admissibility.
We're on redirect. We're not on...
Again, remember, there's no scope rule in Georgia state courts. There's a scope rule in federal court, okay? We're not there, so...
There's no scope rule on cross. I'm not so sure there isn't a scope on redirect.
It's not. There's plenty of case law that talks about you can get into just about anything you want to, even if you forgot something, and it's broad discretion on the court to determine whether or not you're gonna.
Exactly.
Yeah.
Discretion of the court.
Yeah. Okay. Anything else?
Your Honor, excuse me.
Hold on, Mr. Harvey. Anything else, sir?
No, sir.
Okay. All right. Yes, Mr. Weinstein.
Okay, Your Honor, the state is saying that they have established the conspiracy by the fact that they have cited a conspiracy in their indictment, and that is sufficient. That is not sufficient. Just because the state says there's a conspiracy amongst these defendants, that does not mean that they have established a conspiracy. That's established on the witness stand.
In response to Mr. Weinstein, I'm not sure where that comes from, but we are not asserting that because there's a conspiracy count that we've established it. The court has heard the evidence that has been presented thus far, and based on that evidence, we believe that we've at the very least made a prima facie showing that a conspiracy exists. The defendant does not have to be a part of the conversation that the state is intending to offer. He only has to be a participant in the conspiracy. And the jury is entitled to infer the existence of an enterprise and conspiracy from circumstantial evidence. The court can provisionally admit this evidence, and if at any time the court deems it proper to reverse itself, the court can reverse itself and have the jury not consider it. But at this point, Your Honor, we are well in the area where this has been brought up on cross-examination. The witness has testified that he knows about it, and it is ripe for redirect, an area of redirect, when it is relevant evidence that further proves the existence of the enterprise and the conspiracy. So we would ask that the court admit it, provisionally admit it if necessary, but admit it and allow us to publish to the jury before the jury is sent home for the day, because this is
All right, let me look at something else, please. Please, Madam, before I make a decision. Hey, Wes. You should take me. Just go over. That's what she said. She said to us. Pull it up and see what you think. I think that's.
Where you got it? You got Is it on? Thank you.
Ms. Love?
Yes, sir.
These statements that you're seeking to admit, what crimes are they allegedly going to assert
They
a
are,
conspiracy as to?
the count one, Your Honor, which is the conspiracy to violate the Racketeer Influencing Corrupt Organizations Act. For the said accused together with both together and with unindicted co-conspirators, unlawfully conspired to acquire, maintain directly and indirectly an interest in and control of United States property and other personal property through a pattern of racketeering activity, and while associated with an enterprise that unlawfully conspires to conduct and participate in directly and indirectly such enterprise through a pattern of racketeering activity.
All right. Any further argument, Mr. Shart or Mr. Harvey? I've had a chance to take a look at Thorpe versus the state. at 285 Georgia 604, 2009 case, and
Now, what's the year of that case, if you don't mind?
2009.
That's the old law.
In regards to what, sir?
2013, new evidence.
We have a 2019 case, Judge. I don't think that law has been overruled.
What's the 2019 citation? What case is that?
Jones v. State, 305 Georgia 744. It's a 2019 case.
305 Georgia what?
744.
Thank you.
With a pen side at.
I can't find that, this is what I can't hear.
I couldn't hear it either.
It's 305 Georgia 744, Penn site 746. And we'd also point out, Your Honor, that regarding the statements, it doesn't have to prove a crime, it just has to be sufficient. It's sufficient if it proves an element, such as an agreement to participate in an enterprise or a gang. And that, again, is what we are trying to show.
Take a look at the case that she was studying. I don't think it stands for the proposition. It applies the old evidence code. The old evidence code says you can prove it up before. The new one, I don't know what it says about that. That's your understanding?
John.
Yes, Mr. Steele.
Yeah, but if you look at the Jones case, that was just cited by the Honorable District Attorney, was tried before 2000.
Yeah, I got it. And it applies, yeah, Ms. Love. That's part of the challenge of that case is the applicability of that particular rule that you can prove up a conspiracy, at least some prior to the conclusion. existed prior to the new evidence code. So I'm looking for something more recent that shows that, but that seems to be the old code.
I'll get it for you, Your Honor. I'm looking now. Yes. Also, Your Honor, Mr. Nichols, whose IG handle is Digits Lizard, he is a part of these records as well. On page 48805 in the 9/30/2021 conversation, at least that's one place where he is. So he communicates with the participants in this as well.
Which is that one? Which exhibit?
So the record itself is
What state's exhibit is it listed in, madam?
not on any one of these particular pages. He is in the records that these pages come from. He is a participant in a 9/30/2021.
I'm sorry, microphone, please.
He is a participant in a 9/30/2021 conversation in these records.
Oh, that's denied. Subject to proof. We can show more on this political flaws. That is flatly denied.
With not admissibility.
No, I didn't. Hey, Wes.
Judge, we also asked the court to look at Henderson v. State, 317 Georgia Ave, 82 through 83, a 2023 case, August 21st, 2023.
What's the name of it again? I'm sorry.
Can you?
Well, is that Stewart?
Henderson. 317 Georgia, Eagles, 82. Is that correct, Ms. Law? Henderson v. State, 317 Georgia, 82.
Yes, and I'll give a Lexus site 2023 Georgia Lexus 179 or 2023 Westlaw 5338772. And we'll just send it out to everybody. I just sent it to you all. I gave you all the.
Thank you.
Georgia Lexus.
Yeah. Yeah.
Also, Chavers, CHAVERS versus the State 304 Georgia 887, a 2019 case, speaks to the fact that the court can conditionally admit the evidence.
The 304 Georgia 887.
I said 304 Georgia 887, a 2019 case.
Thank you.
Read it either, because I'm having to pay for it extra on my personal phone.
Sure.
So what was the other case that you said you, so the last one you started saying that,
Chambers, CHAERS versus the state, 304, Georgia, 887. And it's head note 6.
For those of you who need to take a comfort break, go ahead and do so. Just make sure you are back within the next 5 minutes or thereabouts, okay?
Hey there, I'm Jesse Weber, and thanks for watching the Young Thug trial here at Law&Crime, where we bring you live coverage of high-profile trials and individuals accused of committing some pretty terrible crimes. I'll tell you one thing, it's a stark reminder that the world isn't always the safest place. Well, that is why I want to shine a light on this week's trial coverage sponsor, Morgan & Morgan. When you're injured, figuring out what to do next can be pretty overwhelming. That's where Morgan & Morgan, America's largest injury law firm, comes in. A whopping 3 million people turn to them every year. And their process is a game changer. Picture this. You submit your claim, you sign contracts, you upload documents, you communicate with your whole legal team, all from your phone. It's that simple. And what's even more impressive, an attorney reviews your case in just 8 clicks. That speed is remarkable. You submit a claim, they start fighting for you. And if you're concerned about costs, well, you only pay them if you win. There's no upfront fee. So if you're ever injured in an accident or at work, you can check out Morgan & Morgan. You can submit a claim in 8 clicks or less by visiting forthepeople.com/youngthug.
Okay, hey Wes. Seems to me because this is changed. Tell me this is. Criticize I'm from fighting. Same time, it's starting to I think it is the most great. I think it's the positive.
He done the program, he didn't want me. I said, yeah, I'm going to clap. Left it at home, and it's not going to happen. Chambers is charged. I'm only one of them, the last one, and the police was there on the creek. I ain't do my first time wearing. I didn't want to. I would have been cut off on TV. I was doing it for our neck week. But I don't like you couldn't. Yeah, he got a sweetie mom. I think Kitchen shirt on. Really? Yeah, I think Kitchen shirt as well. Like Sergeant Jackson? Yeah. I just like all models. But you don't want to make sure. No. You ever seen, you remember Thomas Byron? And all the Byron uniform, like uniform.
This is what I need. Look at
I always studying. I run a lot of affairs.
Sergeant Ingram, everybody back yet, sir?
Yes, sir.
Okay, all right.
Yeah, no, they got that shirt. Guess we ain't got that shirt that little Sergeant Jackson shirt. I want to see the shit like that. I'm not all the sleeves on the inside. I couldn't lose material from the hips, and it'll be so bad. Yeah, man, I could get this thing to be like. There's some more. And follow. Okay, see, I can't find him. I didn't know. We can't just do it. They're going to go and pitch that deep. So this nigga been fucked up my control. I know. Man, brother, he's courtesy teacher out here. We had something in our house and the motherfucker showed up. Yeah, that's cool. Same spring. That motherfucker's kid, that motherfucker. That's pretty ass cool. Nigga, he been calling me like, bye. What's your name? I got you. Oh, goddamn. I will show you all. Yeah. Can he just start coming to work? Yeah. Come to work, though. No.
All right, folks, I've had an opportunity to consider some additional case law relative to the issues of statements in 801D2.
Specifically, I've had an opportunity to take a look at Shavers versus the state. 304 Georgia, 887, the 2019 case from our Supreme Court. And note 14, under OCGA 24-8-801 D2E, the hearsay rule does not exclude a statement offered against a party, which is a statement by a co-conspirator of a party during the course and furtherance of a conspiracy. To admit a co-conspirator statement under 801 D2E, states required to show by a preponderance of the evidence that the conspiracy existed. The conspiracy included the declarant and the defendant against whom the statement is offered, and the statement was made during the course in furtherance of the conspiracy. That is Kemp versus the state, 303 Georgia, 385 at 392. And under head notes 15 and 16, determining the existence of a conspiracy, the trial court may consider both the co-conspirator statements and independent external evidence, although the co-conspirator statement alone does not suffice. And that's Dublin versus State, 302 Georgia, 60, pinpoint 63, 2017. And in considering whether a conspiracy was established for the purpose of the rule, we do not require that the conspiracy be proven prior to the admission of the evidence in question, but only that the conspiracy was proven at trial. That's it's pages 63 and 64, 805 Southeast 2nd, 27. So, State, when did you know that Mr. Steele's examination would open the door?
Your Honor, as we were listening to Mr. Steele.
When? I'm being very specific. When did you realize this? Was it last week? Was it when, before we took the break, or what? Or today?
We've been amassing and going through these records after he opened the door. So
When was that?
From the time that he opened it until
Yes.
today.
When did he open the door in you all's estimation?
We began looking back through them, I would say, at the end of day on Wednesday or third, whenever the last day was we had court, we were looking back through them.
Okay. I don't have any issue with making evidentiary rulings, as you all know, and the threshold thereof. But it would have been nice for me to consider this prior to this. I mean, because I have some options with our jury. I don't like our jurors sitting around for hours on at a time for us to be able to ponder these kind of issues. They're important for all sides, but having them sit there waiting on us is what, I have heartburn as a jurist of many years and also debriefing jurors. So, I could have, here's my teaching point. I could have told the jury not to come in for a period of time. We could have taken this up better part of the morning or whenever, and then they could have done some other things. But I don't have any way of explaining to them now, or attributing fault. I'm not attributing fault to anybody, but do you understand what I'm saying? Everybody, I've told this to everybody. A forewarned judge is a happy judge. We are, because then we get a chance to plan our time. But and I get paid the same amount of money regardless of what I do. But what I don't like doing is having those folks that we have impaneled and sworn to just sit around here and then kind of just wonder what they're going to do. That's the teaching point. So that the fact if you all could do that, it helps out everybody. It just does.
And Your Honor, I did not.
And I know you didn't, but I've told everybody this kind of ad nauseum, and I'm just repeating it again because this is a prime example of what I don't want to do. I don't want our jurors sitting around here. I could have easily told them this weekend, if you had told me sometime last week, Judge, we need to take this up, may take a little bit. And then I would have told them, jurors don't report till 1 o'clock, because we've been at this about 2 hours. And then everybody kind of looks at us like we can't get our stuff together. So that's why I'm saying it's important. I'm telling all of you that. So if you have an issue that you think is going to take up, even if you're wrong about it, just tell the court so I can go ahead and plan accordingly. That's the worst thing in the world, is to have these folks waiting on us. So I just tell you, I stress that to everybody. But that's why I asked you about this.
And I will send out tonight anything that I think might create any issues.
Well, yeah, you just need, so I can kind of let our jurors know, because I'd rather undersell and overperform than just kind of tell them, hey, we're going to be here, and then we don't do anything. So at least from their eyes, okay, I know that what we're doing is very important. So, all right. Having taken a look at the new case, or the cases of Chavers versus the state, Mr. Steele and Mr. and Mr. Sharp, and others who have joined in this motion, I'm going to overrule your objections, and I'll permit the state to admit the aforementioned exhibits. And those being 21 uniform, 22 uniform, 24 uniform, 25 uniform, 25 uniform Bravo, 31 uniform, 32 uniform, 33 uniform, 34 uniform, and 35 uniform. The other reason I tell all of you is that forewarned is happier, is that I can actually get a chance to read these cases and make the best ruling I can, and not keep changing my mind because there's another case that kind of comes up and I haven't considered everything in its totality and perspective. So that's the other reason I would ask that you try and give me as much heads up as you can. Okay? So I'm going to continue your objection, Mr. Harvey and Mr. Sharp. Does anybody else wish to be heard on this issue?
I don't need to be heard, except the Gotham Court has mentioned that I never said it except Mr. Williams. Cross-examination. Every one of my questions was, does this show Mr. Williams furthering any type of criminal street gang activity? I never put anyone else. I just wanted to make that clear that the record is not clear at this time.
Madam?
Judge, those types of questions get into what everybody else is doing on the thread and what is happening, just because Mr. Steele prefaces his questions with, as it relates to Mr. Williams, doesn't change the fact that they are all alleged co-conspirators and they are participating in these various conversations, and that the content of these various conversations thereby shows an element of count one, or two elements, actually.
All right.
Your Honor, if I just use context briefly.
Yes, you may, sir.
Be very clear. when the state says that they are participating in these conversations.
They being the co-accused in this case?
Still well, because they're just saying they, and I think it's very clear, if they're saying participation in the conversation is proof of something, Mr. Stillwell is not participating in those conversations.
Well, that's your assertion, and that's the state's assertion. That's the issue of proof at trial. But what they're saying is the records seem to indicate that there's some evidence or allegation of participation.
No, Your Honor, there's no, the state has never said there's any evidence of participation by Mr. Stillwell in these communications. And I don't believe Mr. Stillwell is the only person that's sitting here.
Well, remember, there's other, I can consider also, and the jury can consider other ancillary facts that have been already established or will maybe established later. So I'll note your objection for the record, sir. Okay, hold on, you two. I gotta talk to Mr. Weinstein, then I'll acknowledge you next. Okay, all right, Mr. Matthews and Ms. D. Williams, you'll go next, okay? Go ahead, sir.
Yes, Your Honor. 35U, I just want to be clear. Is that the Instagram post from Martinez Arnold? Because I want to make sure I'm talking about the right exhibit.
No.
So that was not one of the ones that's been admitted by the judge, by the court just now?
The court simply overruled you all's objection. I haven't even tendered them. I was approaching the witness to show them to him, so I haven't even had an opportunity to tender them, so they have not been admitted.
No, I'm sorry, but is 35U the one, this one here?
No, this is 34.
34U. Okay, so we're also going to object to 34U, Your Honor, as far as bringing that in.
What's your specific objection to 34U that hasn't already been made?
Just foundation. This witness is not the appropriate witness to testify regarding 34U. This is an Instagram post by Martinez Arnold.
And let me back up. Listen, the ones I just mentioned, 21U, 22U, 24U, 25U, 25U Bravo, 31U, 32U, 33U, 34U, and 35U still need foundation.
Okay, thank you.
So preliminarily, the arguments that you're making, I'll note them for the record, and I'll say that they're continuing, but she being the state hasn't laid the foundation quite yet.
Thank you, Your Honor.
All right, Mr. Matthews Sr., sir?
Yes, just briefly, Mr. Huey, we simply join in the objection for all the reasons.
Okay, all right.
Thank you.
Ms. D. Williams?
Mr. Ryan is doing the same thing. Mr. Williams is doing the
Yes, ma'am. Okay, all right. Folks, it's nearly 6 o'clock. I think we're gonna have to call it a day at this point in time. So let's call back in Mr. Stevens, please, and we'll tell our jurors that our plans for tomorrow. Okay?
I'll wait till you come in.
Yeah, wait till he comes back in, please.
gentlemen, please be seated.
President come forward.
All right, thank you, Sergeant Ingram. All right, ladies and gentlemen, as you can see, the hour is nearly almost 6 o'clock, and while I have finished business with our counsel here, it's the end of the day, and unless you have some strenuous objection, I'm going to go ahead and recess for the day, okay? All right, you all sound disappointed. I'm so sorry, okay? All right, but ladies and gentlemen, in all seriousness, there are some times that we take up matters, as I mentioned to you earlier, outside your presence and hearing, and we appreciate your patience because sometimes we don't know how long those will take, and as much as we can go ahead and plan those, we'll try and do so, but I don't want you to attribute anything against anybody. It's just those kind of things happen, and we ask for your patience in advance and continuing patience, okay? All right. Mr. Stevens, be here tomorrow morning for 9 o'clock, okay?
All right.
All right. Don't discuss your testimony with anybody except the attorneys in this case. All right, ladies and gentlemen, before we go ahead and recess, any ministerial inquiry of me? All right. Tomorrow, ladies and gentlemen, if I don't do so, just remind me. I'll cover the schedule for the next couple of weeks, so you can go ahead and take care of other life things that you need to do, and just be informed as much as you can. Okay? So I'll cover that with you tomorrow at some point. But let's go through our customary ad nauseam admonitions. Remember, don't discuss this case amongst yourself. Don't try and do any research at home. Don't phone a friend. Don't phone an attorney. Don't go by visiting the scenes, or otherwise try and augment your understanding. I'll just put it that way by using any other source and or the media or a third party that should try and talk with you about what goes on. And remember, if anybody should try and talk with you, along with Sergeant Ingram, would need to know immediately. But other than that, remember all the other things that we have talked with you about in terms of social media and other things that would, or people trying to contact you. So remember, that's very, very important. It's very, very important you not consider anything else that's otherwise not presented in the four walls of this courtroom. So, and ladies and gentlemen, the last thing is, again, thank you for your patience, your continued patience that you have given us thus far and will continue to give us in the trial of this matter. And I say that on behalf of all of our participants in this case. Okay? So, ladies and gentlemen, unless you have anything of me, if you could be here tomorrow morning for 9 o'clock, we'll get started as close to 9:30 as we possibly can, and then we'll see where we go from the day will lead us at that point in time, okay? All right, all rise. Remember, leave your notepads in the basket in the back. Because I'm not getting started in this time. Wow, it's too much trouble to open up both eyes. It's like I gotta move my head. All right, ladies and gentlemen, please be seated. Okay, anything else I need to consider from the good of the order before tomorrow?
Your Honor, we provided a few videos that we intend to introduce over the next few days, and again, we will just continue to provide anything that may potentially cause problems to the defense so that the court can advance and be.
I'm so sorry, I cannot hear you.
It's okay, Mr. Steele. So that both the court and the defense can be aware, we will continue to do that prior to presenting it to a witness.
Okay. All right. Anybody else?
I I do.
I was only being kind, Mr. Steele. I really didn't want to hear from you, but since you have some more to tell me, what does he want to tell me, sir?
I know they're not marked, but there are 2 email videos that were just referenced, and it is my position that somebody changed the name. It says like Young Thug Blood Gang at the bottom. That does not come with the video. So somebody changed the name, so I'll be objecting. I'm trying to give you a heads up so we don't have
to the name or to the video content itself?
I have to see how the video content is going to be potentially introduced, but it's not the content. I've seen the video. There's a name that somebody put on.
Like the nomenclature of the file?
We'll make sure that it's.
Why don't you talk with Ms. Love, and maybe that can be arranged before or dealt with before we come tomorrow morning, okay?
Okay, and it's both of the videos in
That's fine.
position.
Okay. All right. Anybody else? Again, I was being kind, Mr. Short. Sit down. Okay, what does he want to tell me?
I try to initiate dialogue and hopefully stage gets back to me, but regarding these videos, I would like to make sure
The same videos that Mr. Steele has referenced?
Yes.
Okay, what about them are you trying to add?
I would like to make sure that we have some sort of dialogue about the parameters and also the purpose of those videos, because I will be objecting to just playing the videos, so I need some guidance.
Well, then, why don't you talk with the state about that, and then we can have a further conversation at the appropriate time, okay? All right. Anybody else? Okay, before I close the record down, anybody from the media, have you, do I have points of contact for your counsels? Mr. Seiden? Okay. Okay. Oh, everybody? Okay. Do you have a card for her or anything? Did she send us anything?
She's a service contact.
Okay, all right. So we have it. Thank you, Mr. Seiden. Appreciate it. Okay, unless there's anything else, then I'll see everybody tomorrow morning for 9 o'clock for anticipated 9:30 start time, all right?
Thank you, Judge.
All right, we're in recess. Christina. There you go. Oh, make sure you bring up your devices, please. Thank you, counsels.